Good morning, everyone. Just want to, before we get started, we'll begin to start in a couple of minutes. If you do want to speak at this hearing, you need to fill out one of those pink slips, because if you do not speak at this hearing on the rezoning cases, for the rezoning cases, you cannot speak at the Board of County Commissioners meeting on the rezoning cases. So if you choose not to speak, that's fine. If you choose to speak and you want to speak, you got to speak at this hearing in order to let your voice be heard at the Board of County Commissioners meeting possibly sometime next year. I think it's going to be in January. So I just want to say that for the record. So you have to speak at this meeting if you want to speak on a rezoning case. The other cases, you don't have to, but especially for rezonings, you need to speak at today's meeting. Even if you are represented by an attorney and you still may want to have some words, you still need to speak at this meeting. How you doing this morning, sir?
I'm doing very well.
Welcome back. You guys are back.
Yes, they probably.
I'm good. I'm right here. Okay, I'm right here.
Yeah, I'm gonna pop back there.
Good morning, everyone. Welcome. I'd like to hereby call to order the Escambia County Rezoning Hearing Planning Board. And at this time, I'll ask everyone to please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We'll ask everyone, please turn your phones on silent or vibrate so we don't disturb the meeting. And staff members, do we have proof of publication of the hearing?
Yes, sir.
Okay. Chair will entertain a motion. We have the previous planning board resume minutes and transcript. Are there any additions, deletions, or corrections to those? All right, Chair will entertain a motion to accept as is.
So moved.
Motion, do we have a second?
Second.
All those in favor say aye. Aye. All right. Now, before we get started, we do have a couple of pieces of business. First of all, we'd like to welcome Mr. Kevin Adams from the school board. Ms. Hightower is out of town, and he's filling in for her today, and will be joining us. So good morning, sir. Welcome. I think you're pretty familiar with our procedures. You've seen it a few times and participated.
Came forward. Yes, sir.
Yes, sir. So anything you'd like to add while you're here?
No, sir. I just appreciate being here and appreciate everything y'all do.
All right. Thank you very much. Our next order of business is Mr. Sammons has been reappointed So I think Rachel is going to bring him in officially again for his next term. So Rachel?
Please raise your right hand. Do you, Gary Sammons, solemnly swear or affirm that you will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, and that you are duly qualified to hold office under the Constitution of the state, and that you will faithfully perform the duties as an Escambia County Planning Board member, so help you God?
I do.
Thank you.
Also, Mr. Brisky, we want to make this announcement. As you know, you may not know, but Miss Kia, she will be moving from the county as the planning board, working with the county attorney's office. But we are elated that we have someone who's just as sharp. This is his first day, but don't take him for granted. He's just as sharp, Mr. Matt, and we want to let you know that he will be going forward in the next couple of weeks as the planning board counsel.
Okay, thank you. Welcome, Matt. Good
Thank you,
morning.
Mr. Brisky, and members of the board. My name is Matt Schad. I've been with the county attorney's office for a little over 2 years now, and so I look forward to sitting with this board going forward.
All right. Well, we have lots of fun in here, Matt, so you'll enjoy it.
Yes,
All
we
right.
do.
Let me get back on track here. Okay, we've already done that. Okay, I'm sorry, you did say we had proof of publication and it meets all the legal requirements?
Yes, sir.
Okay, and we've already brought in the
Will you
meeting
make a,
minutes. I'm sorry?
Will you make a motion on the waiving of the legal advertisement?
Okay, yeah, I'm gonna bring in the hearing package and we'll do it all at the same time. Okay, board members and members of the public, the rezoning hearing package for today's date with the findings of fact has previously been provided to the board members. The chair will now entertain a motion to accept that rezoning hearing package with the findings of facts and the legal advertisement into evidence.
So moved.
Motion?
Second.
Second. All those in favor say aye. Aye. Opposed? Motion carries. The rezoning hearing package and the findings of facts of the legal advertisement will be marked and included for all of today's cases. At this time, I'll ask our court reporter to swear in the members of the staff that will be testifying in the rezoning hearings.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth? And so you do affirm.
Do it fine.
Okay. Board members, we've previously qualified all of these individuals that work with the county to to offer expert testimony in the area of land use and planning. Do any of you have any questions regarding their qualifications or their ability to offer that expert testimony? Hearing none, Chair will add these staff members as experts in the area of land use and planning. At this hearing, the Planning Board is acting under its authority to hear and make recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, they are less formal. All testimony will be given under oath, and anyone testifying before the Planning Board may be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to speak must complete a speaker request form located at the back of the chambers. Please note that only those individuals who are here present today and speak on the record will be allowed to speak at the subsequent Board of County Commission hearing. No new evidence may be presented to the BCC. Therefore, all testimony and evidence must be presented today. The Planning Board will provide a recommendation for each rezoning request, which will to the BCC. They will then review the testimony, documents, and exhibits, consider all the closing arguments, and make a final decision. All decisions by the BCC are final, and anyone who wishes to seek judicial review of that decision must do so in a court of competent jurisdiction within 30 days of the date that the BCC either approves or rejects the recommended order of this planning board. All written or oral communications outside of this hearing with members of the planning board regarding any matters under consideration today are considered ex parte communication. Ex parte communication are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As each case is heard, the chair will ask that any board member has been involved in any ex parte communication identify themselves and describe that communication. The rezoning criteria, it's on the board now, as required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. Approval conditions are: the applicant has the burden of presenting competent substantial evidence that the reviewing board establish that the requested zoning district would contribute to or result in logical and orderly development pattern. The appropriate surrounding areas within uses and conditions must be considered and may vary with those uses and conditions, and is not necessarily the same area required for the mailed notifications. A logical and orderly pattern shall demonstrate the following conditions. Consistent with the comprehensive plan, the proposed zoning is consistent with the future land use category as described in LDC Chapter 3 and with all other applicable goals, objectives, and policies of that comprehensive plan. If the rezoning is required to properly enact a proposed FLU map amendment, which we have today, transmitted to the state agency for review, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. Consistent with zoning district provisions, the proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed in the district in the chapter. Compatibility with surroundings. All of the permitted uses for the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6. These uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities that are currently protected by fair housing laws. Appropriate spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently noted. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balance of interest between that isolated district and the appropriate adjoining lands. Appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of the rezoning have changed, the changes are to such a degree and character that it is in the public's interest to allow new uses, densities, or intensities throughout that area, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there is no objections from the applicant, we'll ask the staff to present the zoning maps and photography of the property. Then we'll hear from the applicant and any witnesses that they may wish to call. We'll hear from the staff and any witnesses that they may wish to call. And finally, we will hear from members of the public who have completed a speaker request form and turned it in to the staff members. We have multiple cases on the agenda today, and the staff has worked with a couple of the applicants. We're going to take the case that is on the agenda as Roman numeral 2 with the gentleman, Robert Ward, that will be presenting. His cases will be heard first. This was a request because he has something that he has to attend that he could not change. The first applicant has agreed to that, and so we'll be going into that case first. The first rezoning request for application will be considered Z 2021-15. Robert Ward is the agent for Southeastern Pipe and Precast of Florida, LLC, who is the owner. 2900 Highway 95A, 28.63 plus minus acres from HCLI, which is Heavy Commercial and Light Industrial District, to Industrial District Dwelling Unit Density Limited to Vested Residential Development. Members of the board, I'll ask at this time if there's been any ex parte communication between you, the applicant, attorneys, witnesses, agents, or any fellow planning board members prior to this hearing. Also ask if you have visited the subject site and if you are a relative or business associate to any of the parties. And good morning, Mr. Adams. Any ex parte communication on this case?
Yes, sir.
Okay, thank you. Gary?
No to all. No to all.
Chairman, no to all.
No to all.
Good morning. No to all.
No to all.
No to all.
All right, thank you. Staff, was a notice of the hearing sent to all interested parties?
Yes, sir.
Okay. And was that notice of the hearing also posted properly on the subject property?
Yes, sir.
Okay. Mr. Ward, any objection to the maps and photography?
No objection.
Okay, no objection. Staff, who will be presenting?
John Fisher, Senior Planner.
Okay, you want to go with the pictures and photography?
Okay. All right, here we have the location and wetlands map of the subject property. This is the future land use map that is currently will be going to the planning board as industrial. If you remember last month, the board recommended approval for mixed-use suburban to industrial as a housekeeping item, and this is kind of the same thing. This is just a housekeeping item case that we're trying to make it consistent with what's on the land there. This is the current zoning, 8CLI. This is showing the existing land use around the property. This is the aerial map. This is the public hearing sign looking 95A north. This is looking south along 95A. This is on Chipper Road looking west, and Chipper Road looking east. And this is looking northwest on Highway 95A and across Highway 95A. Those are the maps and photographies.
Okay. Mr. Ward, if you'll come forward, please, sir. Good morning, sir. If you'll please be sworn in and then state your name and address for the record.
Raise your right hand, sir. Do you solemnly swear that the or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. My name is Robert Ward, 9909 North Cove Avenue, Pensacola, Florida, 32534.
Thank you. Good morning, Mr. Ward.
Morning.
Couple questions for you. Have you received a copy of the staff's findings of facts in the hearing package?
I have.
Thank you, sir. Do you understand that you have the burden of providing substantial competent evidence that the proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with the Land Development Code?
Yes.
Okay, thank you, sir. In this case, members of the board, you may have remembered we did a small-scale amendment on actually all of the cases that Mr. Ward is here for today. At this point, Mr. Ward, I believe that Mr. Campbell is here as one of your witnesses. Is that correct?
I'm sorry, he is supposed to be here.
Okay, he's not here.
He
Okay.
has not shown up.
What I'm getting at is because you're in agreement with the staff's findings, we can do an expedite on this, which means we don't go through and read every single thing into the record.
Yes, absolutely.
And so let me just ask members of the public, is there anyone here that wishes to speak on this case? All right, hearing none, we will hereby close public comment. In that case, John, if you would just like to give just that it's consistent in each category and we can expedite.
Sure. John Fisher again. Just for the reference, last Thursday at the Board of County Commissioners meetings, the board did vote to approve all 3 small scale cases. So those were approved, all to industrial. So these next Mr. Ward's cases today are just basically another housekeeping item where we're trying to get the land use that is on the property to the existing industrial zoning category for they can be consistent for any type of sale maybe happen in the future or any type of whatever they'd like to do with future projects. They are consistent with all categories of the zoning case for the comprehensive plan and the LDC. Staff's findings were inconsistent. Spot zoning, there was no spot zoning due to the size of the proximity of the parcel. Change in land uses, environmental, there was no inconsistency. Everything on the properties are existing. This is just basically a housekeeping item.
Okay. Mr. Ward, you accept the findings as your own in the case?
I do.
All right. Chair will entertain a motion on this one.
So moved.
Okay, motion to approve. Do we have a second?
Second.
Second. Discussion. All those in favor, say aye. Aye. Opposed? All right, motion carries. We'll move directly into the next case. Mr. Ward, you're welcome to sit down while he presents the photography, but we're going to have you right back up here. We'll do the same thing, expedite them. Okay, on this next case, which is case Z 2021-16, members of the planning board, again, I will ask you if there's been any ex parte communication with the applicant, agent, members of the public, fellow planning board members, or if you're a business associate or relative to any of the parties. And again, Mr. Adams.
No to all.
No to all. No to all.
Chairman, no to all.
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 Okay, thank you. All right, let me see here. All right. Go ahead with just the maps and photography, John.
Thank you. John Fisher, Senior Planner. All right, for Z 2021-16, this is the location wetlands map just south of the parcel that we were just talking about that is adjacent to. Here's the future land use map that was adopted last Thursday. This is the zoning map, HCLI. This is the existing land use map. This is the aerial. You can see everything's already developed out there. This is the public hearing sign, East Quintet Road looking west. Public hearing sign looking south along Highway 95A. Highway 95 looking east. Looking south across Quintet Road. This is looking west across Highway 95A. This is looking east along Quintet Road. This is looking northeast from Quintet Road. This is looking north from Quintet Road at the subject property.
Okay, thank you. Mr. Ward. Sir, I'll remind you, you're still under oath. Did you receive a copy of the staff's hearing package and the findings of fact?
I did.
And on this case, do you understand that you have the burden of providing substantial competent evidence that the comprehensive plan furthers the goals, objectives, and policies of that plan and is not in conflict with the Land Development Code?
I do, yes.
Okay. And let me ask, on this case, Z 2021-16, are there any members of the public here to speak on this case? Hearing none, the chair will close public comment. And again, John, if you'll go forward with expedited version.
Yes. So yes, the staff's findings are consistent with number 1 and number 2, the Comprehensive Plan and Land Development Code, as well as spot zoning. This is not considered spot zoning due to the adjoining parcels are also zoned the same, or in a rezoning case to make them all the same. Compatible with surrounding uses and change conditions. There are no change conditions, and they are compatible with the surrounding uses.
Okay. And in this case as well, John, the small-scale amendment was approved?
Yes, sir, last Thursday, December 2nd.
Okay, thank you. Mr. Ward, do you accept those findings as your own and agree with them?
Sure do.
All right, thank you, sir. Chair will entertain a motion on this case.
Move to approve.
Second.
Second, any discussion? All those in favor, say aye. Aye. Opposed? Motion carries. All right, and the final case for Mr. Ward, Z 2021-17. And at this time, on this case, we'll do the pictures, and then we'll bring you up one more time, Mr. Ward. All right, go ahead, sir.
John Fisher, this is zoning case Z 2021-17. This is the location wetlands, which is just in the southwest corner of the two recent parcels we have been discussing from the previous zoning cases. This showing now the adopted future land use from December 2nd BCC meeting. This is the zoning case, 8 CLI, current zone. This is existing land use map. And this is the aerial. This is the public hearing sign, Highway 95A looking north. This is Highway 95 looking east at the subject property. This is Highway 95 looking southeast at the subject property. This is looking along Highway 95A south. This is looking Highway 95 looking north.
Okay, thank you. Mr. Ward, once again, I know it's redundant, but on this case, have you received the hearing package and the findings of facts?
Yes, I have.
And on this case, do you understand you have the burden of providing substantial competent evidence that it's consistent with the comp plan, furthers the goals, objectives, and policies of that plan, is not in conflict with the land development code?
I do.
Okay. Is
Mr.
there-
Chairman,
I'm sorry.
if I could interrupt.
Yes, sir.
Did the board notify or announce any ex parte communications for this specific case number? If not, I would suggest.
I'm sorry, you're correct. Thank you.
Thank you.
He's already earning his paycheck, Horace. See that?
He's already on point.
Thank you, Matt. I appreciate it. Trying to keep it moving here. Members of the board, on this case, Z 2021-17, has there been any ex parte communication with members of the board, the public, the agent, applicant, attorneys, witnesses? Have you visited the subject site, and are you a relative or business associate of any of the parties? Mr. Adams?
No to all.
Thank you.
No to all. No to all.
Chairman, no to all?
No to all.
No to all.
No to all.
No to all.
All right, thank you, and thank you for catching that. Trying to go fast to be respectful of everybody's time. All right, is there any members of the public that are here to speak on case Z 2021-17? Hearing none, we'll close the public comment portion, and John, if you'll just give us a summary of this one as well.
Thank you, Chairman. This is the last of Mr. Ward's zoning cases. This is also just a housekeeping item. Again, this small-scale map amendment, future land use, was approved December 2nd, last Thursday meeting, to industrial. Rezoning this to industrial will make everything consistent with the land development code. This is a housekeeping item. It is, the staff finds that it is consistent with the land development code, comprehensive plan, compatible with the surrounding uses, and change conditions. There are no change conditions or spot zoning for this parcel.
Okay. Mr. Ward, do you accept these findings as your own and agree
I
with
do.
them? Okay. Chair will entertain a motion on 17.
So moved.
Motion to approve.
Second.
Second. Any discussion? All those in favor say aye. Aye. Opposed? All right, motion carries. Good luck to you, sir.
Thank you, Mr. Chairman,
All
board
right,
members,
thank
I
you.
appreciate it. And I'd like to thank the staff for working with us on this to get it cleared up.
Absolutely.
Thank you. It's been a long process, but we're so glad we was able to bring it for the board to proceed to the next level. Thank you, Mr. Ward and Mr. Campbell, for your patience with this project.
All right. Thank you. Our next case, I know we're going to have a presentation or a presenter on Teams as well as in person, who is going to be taking the lead? Is it the person who is here today?
Yeah, I can take the lead.
Okay. And are you Chad Rome?
Yes, sir.
Okay, all right. Let me go through our ex parte communication and make sure we have nothing there. This is case Z 2021-13. Members of the board, has there been any ex parte communication between you, the applicants, agents, attorneys, witnesses, fellow planning board members, or anyone from the general public? Have you visited the subject property, or are you a relative or business associate to any of the parties? Mr. Adams?
No to all.
No to all.
No to all.
Chairman, no to all.
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 All right, staff, was notice of this hearing sent to all interested parties?
Yes, sir.
And was it also properly posted on the subject property?
Yes, sir.
Okay, thank you. Mr. Rome, do you have any objection to the staff presenting the maps and photography at the beginning of the case? No, sir. Okay, he's indicated no, so John?
Thank you, Chair, board members. All right, so this is zoning case Z 2021-13. This is the location and wetlands map. This is the future land use map. This is the zoning map. This is the existing land use map. This is the aerial map. And if we can actually go back to the maps here, I think there should be a correction on these maps. These were corrected. This parcel here is also included. This is part of U-Haul's stormwater pond. This should be included in the map for the rezoning as well.
Okay, and so, based on the decision that the board makes a recommendation, then the map would be updated in the package?
Yes, it should have been updated. We'll see if we can find those maps and maybe show you if we, as we get moving through this process. The parcel reference numbers and the survey was included to include that parcel.
Okay.
So we do have the survey showing that.
But it looks like all three of the maps that you just scrolled through need that correction.
Correct, sir. And they are corrected. It was, I don't think the PDF got updated on those.
Okay.
Part.
I would recommend that when making a motion, that you include that as part of your motion to make sure that the maps are included.
Correct.
Mr. Powell, did you have something?
I just want to make sure through our attorney if we need to make any mention or motion now to include the amended maps if there are those now, or if it's made part of the motion, is that acceptable?
It wouldn't hurt to make that motion now.
Okay. Chair will entertain a motion.
Make a motion that we include the amended maps once they are corrected with any motion.
Yes.
Okay. Second.
Second.
Any discussion? All those in favor say aye. Aye. All right. So the findings of fact will be updated with the corrected maps regardless of the motion that the planning board makes.
Correct. And the findings of fact should have that parcel number in there at the very top. So we just need to correct the map. Correct.
Okay. All right. Very good.
Here's the public hearing sign looking south on Davis Highway. This is looking northwest from the subject property. This is looking at the subject property from Davis Highway. This is looking northeast at the subject property from Davis Highway. Looking north along Davis Highway. Looking west across Davis Highway. I got a school vehicle in there. Public hearing sign on Bloodworth Lane. Looking east along Bloodworth Lane. This is looking north at the subject property, the entrance off of Bloodworth Lane. And west along Bloodworth Lane. And south across Bloodworth Lane. Those are the pictures and maps.
Okay. Thank you.
Okay, go ahead.
Staff members, quick question. On our agenda, we have Gernor Carr, I believe it's how it's pronounced, as the agent. Do we have the proper documentation showing Mr. Chad Rome also as an agent for the?
Can you repeat the question again? She was pulling up the maps here.
We have Mr. Chad Rome here in person. I'm trying to find out if he was appointed by the owners as an acting agent on it, because we have Gornor Carr as the acting agent for the case.
Yeah, Gunnar, is the affidavit the one that's been signed for this case?
Okay.
We don't have an affidavit for the other. It's just an email that's been presented to us, not an actual affidavit.
Okay. So I think, just to make sure that we have the appropriate legal standing, we'll ask them to open and introduce Mr. Chad as one of their witnesses or a representative, and that way we get it covered. So can we bring them up on Teams?
Gunnar, are you there?
Hi. Good morning. I'm here.
Hi, good morning, Gunnar. This is Wayne Brisky, the chairman here of the Planning Board, and we're going to ask you to be sworn in. These proceedings are done under oath, so we have a court reporter here who will swear you in, and then please state your name and address for the record.
Will do. Thank you.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole
I
truth,
do.
and nothing but the truth?
Okay? It's indicated that she does. Gunnar, have you received the staff's findings of fact and the rezoning hearing package in your case?
Yes, sir.
Okay, and do you understand that you have the burden of providing substantial competent evidence that this proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with the Land Development Code?
I do, sir.
Okay. Now, we have Mr. Chad Rome here. Is it your intent to call him as a witness to testify here in person, or would you like to give an opening statement?
I would definitely like Mr. Chad Rome to testify and represent us. He is our local marketing company president, and he has worked with the community for a long time, so he is very qualified to represent this project.
Okay, very good. And I understand you gave the staff members an email indicating that he would be representing as well.
Yes, I did.
Okay. All right. We'll ask Mr. Chad Rome to come up then. Sorry about all the legal wranglings. We want to make sure we get it
Hopefully
right.
I live up to her statement.
Sir, if you'll be sworn in, please.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Would you spell your last name down here?
Rome, R-O-M-E,
Thank you.
like Rome, Italy.
Okay, sir, your name and address for the record?
Yes, Chadwick Rome, P.O. Box 10644, Pensacola, Florida, 32524.
Okay. And I've already asked the agent if they received the rezoning package and the staff's findings of facts, but have you also seen a copy of those?
Yes, sir.
And you're familiar with them? Okay. All right, sir, you may proceed. Give us your presentation.
Yeah, thank you for having me here. We've done some work with you guys in the past. I've really got a good relationship with your team with doing the former Kmart on Mobile Highway. We're looking forward to breathing some new life into this property. As many of you know, that it sat pretty much vacant for several years. It's been a problem when it comes to home challenged individuals as well as some crime. I did have the opportunity to speak to both of the abutting neighbors, and their support was overwhelmingly positive. I went and knocked on their door, and they welcomed us. The neighbor that's closest to the property actually had to put up security system, and he doesn't even want to, walk outside without a gun in hand. So he's had some problems with some break-ins and things like that, and I think that our presence, not only with that, would definitely help. We believe that the rezoning with the uses is a perfect fit for what's going on. As most of you or everyone probably knows, we have the abutting property that's adjacent to the subject property.
I hate to cut you off, but I think you told me earlier that you wanted some evidence you wanted some material that you
Oh,
wanted
sure,
presented. Yes, sir.
sure.
Let's get that in, because they got accepted by the board.
And Chair, while they are doing that, we do have the actual map here in front of you. This is the corrected map. We
Okay.
have all of them.
We put together a couple presentations. It looks like I'm a little bit short, so I apologize for that.
Okay, could you present them to the attorney? And could you explain to us exactly what the presentation is, who prepared it, and where the data came from?
Yeah, it was presented by our staff. Gurnor does a fantastic job with these. It goes into a lot of, it's got our history with U-Haul and what we bring to the community. It talks about some of our sustainability projects and what we've done with adaptive reuse projects like the one with the Kmart. We really do our best trying not to tear down buildings. We try to use some the historical sites and really try to breathe back life into some of these older properties. So that's pretty much what the presentation entails. There is some data that's consistent with our project narrative as well, where it has some of the data regarding the trip usage and things like that, and how it is not a significant impact on the community and infrastructure with self-storage in the self-storage industry.
Okay, and in the document that you're presenting as evidence, do you agree with all the information in there and believe to the best of your ability that it's true and accurate?
Yes, sir.
Okay. Chair will entertain a motion to accept into evidence.
So moved.
Do we have a second?
Second.
Second. All those in favor, say aye. Aye. All right, we'll mark as applicant's Exhibit 1. Mr. Shao, do you have any comments or concerns about the document being presented?
No, Mr. Chairman.
All right, thank you, sir. We can share them, yeah, that's fine. All right, sir, you may proceed.
So we think it would be a perfect fit, and we really look forward to working with your staff again on another project. And I hope that we get the approval to get rezoned.
Okay. Let's draw your attention to the staff's findings of fact and specifically the criteria. Are you in agreement with the staff's findings of facts in all of the categories, or do you have any alternative findings that you wish to present?
I'm in agreement.
Okay. All right, very good. Do you have any other witnesses that you wish to call before we let the staff do their presentation?
I do not. Gurnor, would you like to speak on anything?
No, I'm pretty good. Thank you for explaining our project so well. I'm good. Thank you.
Okay. Sir, you're welcome to stay, or you can have a seat, and we'll let the gentleman present the staff's findings, and we'll bring you back up.
Chair, do we have any public speakers on this one?
Did we have one more on this?
If not, I can give the short version.
Okay. Any members of the public that are here to wish to speak on Z 2021-13? Okay. Hearing none, we'll close public comment portion, so we can use expedited if everything's consistent.
Thank you, Chair and board members. This is Z case 2021-13. Staff finds that it is consistent with the comprehensive plan, the land development code. This is not spot zoning in any means, with the adjacent property already having the current zoning. As well, it is consistent with a compatible land use, and there's no significant changes to the property or surrounding area at this time. Staff recommends approval.
Okay. All right. Mr. Rome, come back forward, please. Because we don't have any speakers and you're in agreement with all of the staff's findings, they all are consistent. Do you agree with all of those findings and accept them to be your own?
Yes, sir.
Okay. Chair will entertain a motion on this one.
So moved. So moved to approve.
Move to, okay. And do we need to mention the maps again, or we're already good with that?
I think because we already made the motion.
We're good, okay. All right, this is a motion to approve with a second, including the updated maps and the findings. Any further discussion? All those in favor say aye. Aye. Opposed? Motion carries. Good luck with it, sir. Thank you.
so much. Thank you.
Okay, our next case, case Z 2021-18, James Butler acting as the agent for Big Fly Holdings LLC, the owner, 117 Pace Parkway, 7.44 acres plus minus, low-density mixed use, 7 dwelling units an acre to commercial district, 25 dwelling units per acre. Members of the planning board, has there been any ex parte communication between you, the applicants, agents, attorneys, witnesses, fellow planning board members, or anyone from the public? Have you visited the subject site, and are you a relative or associate of any of the parties? Mr. Adams?
No to all.
No to all.
Chairman, no to all?
No to all.
No to all.
No to all.
No to all.
Okay. Staff was notice of the hearing sent to all interested parties?
Yes, sir.
Okay. And was it also posted properly on the subject site?
Yes, sir.
Okay. Mr. Butler, do you have any objection to the staff presenting the maps and photography before we begin? I'm sorry?
Brian Hoffman, counsel for Big Fly Holdings LLC. We submitted our statement yesterday indicating my ability to act as agent for him today.
Thank you, sir. And as being an attorney, not sworn in, you're held to a higher set of standards, I think, with the with the bar. So you understand the quasi-judicial process very well, I'm sure. So,
Mr. Chairman?
if you're okay with them.
We had a submittal as, it wasn't part of the packet, it was sent to us yesterday concerning Mr. Hoffman. He is an attorney, so I'm not sure if it's necessary as an authorized agent
Okay.
for that.
If you'll state your name and address for,
Yeah.
or your name and position for the record.
Caleb McCarty, ASCP, Escambia County Senior Planner.
Okay, thank you, sir.
Perhaps we could just make a motion to amend the package to include that, just so there's no issue on evidence or the fact that that agency's in the packet.
Yes, sir. We will certainly do that. Chair will entertain a motion to accept the attorney as the agent for the owner.
So moved. Second.
Motion and a second. All those in favor say aye. Aye. Opposed? Okay. Are you okay with him presenting the maps and photography before your presentation?
I am.
Okay, sir. All right, go ahead.
All right, here we have the location and wetland maps. There's no wetlands indicated on the property. This is our future land use map showing mixed-use suburban. And here is our 500-foot radius zoning map showing that the zoning is low-density mixed use. This is in a CRA overlay, but it's not defined. It's known as cantonment. Here's an aerial map showing the location. And we have a existing land use map. If needed, we can reference back to this showing the land uses in the area. And I think this is a duplicate as well for the aerial. This is our notice of public hearing sign showing placed on the property. This is looking on the site. It's a fairly large site, about 7 acres, so this would be the southern half of the site. There is an existing building on the northern portion of the site. This is looking west along Muskogee Road, southern portion of the site. And this is looking across Muskogee Road from the site. That is International Paper. This is looking east along Muskogee Road. And that concludes the photography and maps for this case.
All right, thank you. Board members, any questions on those maps or pictures? All right, thank you. Mr. Hoffman? Sir, just a couple questions as we open the case. Have you received a copy of the staff's findings and hearing package?
I have.
All right, sir. Do you understand that you and your client have the burden of providing substantial competent evidence that the rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with the Land Development Code?
Yes, I understand.
Okay, thank you, sir. Please proceed.
Okay. First of all, if you wouldn't mind putting the aerial map back on the screen, just for a point of reference. Okay. Now, unlike the ones you've considered thus far today, the staff findings are not in favor of all these categories. So I want to walk through before we present the evidence so that everybody has a framework on what we're looking at and so that I can answer any questions. I don't want to be soliciting testimony if someone's got a fundamental question about a concept. And if you look at these criteria, just to review what they are. Number one, consistent with the comprehensive plan. The findings are that it is consistent. We don't object to those findings. Number two, consistent with the zoning district provisions. Staff findings also determine that. Now, for both of those categories, they also include some however, some additional language that is contrary to the conclusion, but we are not in agreement with some of that additional language. But ultimately, for those first two categories, we are in agreement with the staff finding conclusions. Now, for the last three, the staff findings are not favorable. That is for compatible with surrounding uses, appropriate if spot zoning, and then number 5, appropriate with changed or changing circumstances. So those last three are going to be a lot of what our focus is on. However, some of the commentary that was included on those first two provisions are relevant. Now, first of all, I want to bring you up to the screen, and actually, could you put the existing land use map? All right. This is the property, and as many of you who are familiar with this area know, you've probably driven by what is now the old Champion Golf Course. That's it in the northeast corner. The middle of the property, though, is the front part of it is vacant. The north part of it has a 13,000 square foot property on it. At one point, back when this was constructed, this was the International Paper property to the south, and then to the north of it is the residential subdivision that was created that was primarily the people who had worked at the plant. Now, that 13,000 square foot structure that looks like an H, says vacant office, at one point, that was actually the Timberland headquarters for International Paper. They had the union activities there, the credit union. It was a substantial office location. Now, at this point, it has been vacant. It has recently been identified for a conditional use permit for an assisted living facility. That is actually in the packet, so there's not any question that that's what the current conditional use has been for the property. Now, the roads are also important that surround this because they're addressed in the staff findings. At the south portion of the property is Muskogee Road. Now, for those of you that don't know, that road travels up until you hit 29. That is essentially facing the vacant portion of the property. Now, for the Pace Parkway property, that goes in between the east side of the property and the residential side. And in the past, that was used to service a very large office complex. Now that's going to be assisted living facility, which should reduce substantially on that traffic. And then Pine Street is not really an access point to the property at all, but it nonetheless abuts on the north. So that is the framework of the property. And then most notably to the south is the International Paper.
Mr. Hoffman, just a quick question on this that we're looking at. What is the significance of the blue hash marks along the residential road?
That is utility corridor
Okay.
easement. I believe it's primarily the utilities that are servicing International
Okay.
Paper.
Okay, all right. Thank you, sir. Go ahead.
Okay. And if you could, please put up the zoning map. Okay. Now, what you'll see is for the zoning, it is low-density mixed use. And that's also the little triangle property just to the west. That is currently vacant, but that is also low-density mixed use. The residential is medium-density residential, and then below that is the industrial use. Just from a spectrum on the intensity of usage, obviously that industrial is one of the most significant intense uses for the property. Now, when you get into the categories, I want to kind of go through now each of those categories now that you have a framework of what we're looking at. The category 1, consistent with the comprehensive plan. The conclusion of the county is it is consistent. Basically, we do not need to do any future land use amendment for that. So I'm not going to address that because we are in agreement with the findings on that portion. However, when you get to the zoning, it does say it's consistent and that, number one, it meets the location criteria because what's being sought here is to rezone it from low-density mixed use to commercial, which is consistent with what the historic use of the property has been and also what the current conditional use is. You can't have an assisted living facility under the current zoning, which is why that conditional use was approved. Right now, the conclusion on that criteria is consistent, but there is a provision in those findings that state some concern by the transportation planner, and I'll read verbatim exactly what the one sentence is that really addresses the concern. It states, the primary concern is between the subject property driveway on Pace Parkway and Muskogee Road. This segment of Pace Parkway would be impacted by higher intensity land use. Now, there's no explanation as to where that concern is coming from. It's more or less just a conclusory statement. But a key portion which we'll address is that the assisted living facility that's now operating as, has now received a conditional use actually reduces the traffic that would be going on Pace Parkway. That is the primary road that would be affecting the residential. And as far as Muskogee Road, that would be the portion that would be used to access the south portion of the property if it was used for commercial purposes. One thing that's not in the packet at all is that Muskogee Road has actually now been designated a freight corridor. The two documents that I am going to be wanting to get into evidence is one, a Board of County Commissioners Resolution 2018-27, at which point the commissioners adopted a resolution for FDOT funding to make that a freight corridor. Later, BOCC minutes on March 5th, 2020, a 4-0 approval was made to actually consistently adopt the fact that this is now a freight corridor. That's relevant to the extent that Muskogee Road is being characterized as though it is a low traffic pattern residential road. It's not. It is a freight corridor. So for those two exhibits, just for a housekeeping purpose, I would like to go ahead and submit those.
Okay. If you'll submit them to the board attorney, please, and please describe to us exactly where they are and what the origin of them is.
The packet includes several documents in the working file and in the actual statutes. The only two that I'm actually seeking admission on is Board of County Commissioners Resolution 2018-27, which is the one that dealt with Muskogee Road as a freight corridor. That's available on Muni Code that has the public records available with the stamp. I've provided a copy that includes the signature of that resolution. So it is essentially a public record.
Are you asking for them to be entered together or individually?
Individually.
Okay.
That could be Exhibit 1. And then Exhibit 2 is the Board of County Commissioner minutes from March 1st, 2020, which is a 4-0 approval. I've included the entirety of the minutes. Really, it's only page 30 we're dealing with, which is a 4-0 approval where it is addressing that Muskogee Road as a freight corridor and the FDOT grant incentive to fund that.
Sir, do you have a definition of a freight corridor handy?
No, I do not have. It is discussed in that, both the resolution and in the minutes, where basically because there is freight activity traveling, for example, the industrial use ones you just did on the first 3 projects are about 3 miles away that are on that same CR 184 corridor. Basically a change in use where they've identified that there's substantial freight going through that area, and FDOT provided grant funding, which the county more or less capitalized on. And these minutes in the resolution are the county's actions where they were going through that effort to get it designated a freight corridor.
Would staff be able to look that up for us?
That would require a review, basically, from the transportation department as subject matter expert on those on that provision. And I think Carol Malone, she's here, maybe she can provide some insight, and she is AICP as well as a subject matter expert on that, if that's.
Well, I think it's important because the gentleman's introducing this as evidence in the case. I think it would be important to hear from her. We'd like to get information from the county so they can verify this. So if we could, I'll tell you what, let's let her come up during the staff's presentation and give us the information. Go ahead, Mr. Hoffman.
Okay.
All right, we need to address your exhibits that you're asking to be entered. Mr. Stroud, do you have any concerns about the offered exhibits?
No, Mr. Chairman.
Okay, Chair will entertain a motion. There are two exhibits, Exhibit 1 and Exhibit 2.
I'll make a motion to enter both Exhibits 1 and 2 into the record.
All right. Do we have a second?
Second.
Discussion? All those in favor say aye. Aye. Opposed? All right, we'll label them as Exhibits 1 and 2 for the applicant. Applicant Exhibits 1 and 2. I'm sorry? Yes, just, I think we know what it is, and we'll get testimony from the transportation staff member, but go ahead, sir.
Okay. And significant on the staff findings, there is no finding that this is not a traffic corridor. What there is a statement indicating that if you zone this commercial, it's going to impact the usage on that road, and it doesn't mention at all that that is a significant high-traffic area with the freight corridor. So that's the purpose of the evidence. I understand we'll address it when she comes up, but that's, I just want to
ask a question on, as far as that goes. I have a feeling I know why the staff would present it that way, being that we don't typically look at project-specific when we're doing a rezoning. We look at all accepted uses for a commercial district. Caleb, is that why that was included? Because it potentially could be something other than the assisted living facility?
Right, and that's, the assisted living facility was approved through the Board of Adjustment for allowance and to utilize the building. The rezoning with the uses is what's being reviewed here. There's no need for the rezoning for an assisted living facility because it's already allowed by right and been approved. So we didn't necessarily take that into consideration. We just considered the uses in the rezoning request of what we do, what could go there in the commercial zoning. So again, it's allowed by right. They received conditional use approval from the Board of Adjustment, and there's really not an issue there from staff.
Okay. Go ahead, sir.
okay. When you go to the next category, the third one, compatible with the surrounding uses. The staff findings were that it was not compatible with the surrounding uses. And the standard is for the compatible use, just to clarify, a condition in which land uses, activities, or conditions can coexist in relative proximity to each other in a stable fashion over time such that no use, activity, or condition is unduly negatively impacted, directly or indirectly, by another use, activity, or condition. Now, the analysis on that portion essentially makes conclusions, but I want to read to you what the conclusion was. The proposed rezoning to commercial would encroach on the existing well-established residential subdivision. The industrial property to the south functions as a paper mill, as an intense industrial use that has coexisted with the residential subdivision for many years. But the conclusion is to make this parcel commercial would essentially be incompatible. Given the paper mill operations to the south, that essentially defies common sense when you apply that standard. More importantly, if you're going to give an exception, the way it casually makes an exception for the intense use of the paper mill, then go back to the original intent. When that property was operated by the mill, it was essentially used for commercial purposes. The vacant triangle piece that is to the east, that actually used to be an old post office. So right now, the history, and this being a commercial use, is actually consistent with what this was used from the very beginning. So for that reason, we'll be presenting evidence on that point that it is compatible with the use. But it segues into the next one, which it deals with spot zoning. And the standard for spot zoning is zoning applied to an area of land, regardless of its size, that is different from the zoning of all contiguous land. Such isolated or spot zoning is usually higher in its density or intensity of use than the adjoining zoning may, and therefore extend privileges not generally extended to the property similarly located in the area. Spot zoning is not itself prohibited, but due to its potentially adverse impact on adjoining zoning, it carries a higher burden of demonstration that, if authorized, it will contribute to or result in a logical or orderly development. Now, number one, for the only contiguous parcel that is not separated by a road, which is the little triangle piece that used to be the post office, that property owner is not opposed to this zoning amendment at all. And when you get to the one piece, the conclusion reached by the staff findings are that it is spot zoning and it's not allowable spot zoning. What's missing from that analysis is that when you go into Article 3-2.6, which is low-density mixed use, all the way to 3-2.12, which goes to industrial, there is a sub-F paragraph in each one of those commercial provisions. And what it addresses is transition. That portion, if you read the staff findings, that subparagraph F is not included in the verbatim portion of the statute, and that is the key issue. When you look at this map and you see low-density mixed use, that commercial is a segue to industrial, meaning it is a transition. The entire, and there's specifically allowed language that when you're dealing with the commercial zoning, one of the reasons to get commercial zoning, if you're transitioning to a higher, to using basically a lower use to the highest use, and then you've got something in the middle. That's exactly what's being sought by this rezoning, and it's consistent with what the original use of the property was. That's very different than, for example, if you look in the purple industrial, if you just stuck residential in the middle of that, or some use that wasn't consistent with any prior use, completely surrounded by something different and does not act as a transition, that's different. This is a transition, and there's nothing in the findings of the spot zoning portion addressing why that transition should not be allowed, because it's consistent with what the provisions of the Land Development Code actually provide for. In fact, if you adopt the spot zoning provisions that have been explained in the staff findings, you essentially have to read subparagraph F out of each one of those rezoning provisions on reasons why it's allowed when you're actually seeking a transition. The final one is the appropriate with changed or changing circumstances. It's a brief conclusion there, but it states the land uses or development conditions with the area surrounding and on the site itself have not changed. The request appears to be premature for the area. Based on the change in Muskogee, so from 2018, based on the Exhibit 1 and 2 about what the changes are in that road, that's the exact opposite. That is a changing situation, at least from what it was at the very beginning when it was developed. But at the beginning, it was being used for commercial purposes. So for those reasons, it's our position that the appropriate changing circumstances, the usage on Muskogee, which would be the only real consideration why that should not be granted, doesn't apply at all. In fact, it's the opposite, and it's not addressed by the findings by the county at all. Now, some points I think are significant. The only contiguous adjoining property owner is not opposed to this at all. Another key point is this is a rezoning. It is not the development order process. Even if this is rezoned, whatever usage is going to have to go through the development order process. And right now, it appears the comments are directed at some particular use, but right now, there is no particular use that's being proposed. It is a change in zoning. Those are two separate, distinct concepts. And I've also got some additional closing arguments, but I kind of want to wait on those until we get the staff findings. But I'm ready to move forward with presenting our evidence, but I want to make sure there's not any questions before we do that.
I'd like you to expand on your last statement where you indicated that the comments address a specific use. If you could just draw our attention to that and expand on it a little bit.
Well, the staff findings on the three categories that I just went through primarily are conclusions. They don't provide any analysis. And right now, we're already having a conditional use on the property that would not be allowed under the current zoning. You've got the original usage of the property. It doesn't make sense why the staff findings make the conclusions they did for the last three categories. The only way it makes any sense is if there's some particular use that is intentionally trying to be avoided based on moving to commercial zoning, but that's not being addressed at all in the staff findings, which is why it's important to identify that this isn't the development order process. This is a rezoning process. And if there's not an issue with Muskogee Road or any specific issue, that it's not appropriate just to make a conclusion that you can't use property. The whole purpose for the rezoning is to allow the highest and best use of the property. And that is not addressed in the staff findings beyond a simple conclusion. That's the problem.
Okay, thank you.
Okay. Do you have any other questions?
I don't at this time. Go ahead, sir.
Okay. Would you like us now proceed with our evidence?
Yes.
Okay. We're going to call our first witness, which is Mr. James Butler.
Sir, we'll ask you to be sworn in and state your name and address for the record, please.
James Skip Butler, 3044 East Kingsfield Road, Pensacola, Florida, 32514.
Okay.
Raise your right hand, sir. Solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Mr. Butler, could you please explain your relationship with the...
Mr. Hoffman, I'm sorry, they record everything and it's broadcast, so you have to really speak towards the microphone so it'll all pick up and record. Thank you.
Mr. Butler, could you please explain your relationship with the owner of the property, Big Fly Holdings LLC?
I'm a managing member of Big Fly Holdings.
Okay. And are you authorized to provide testimony on behalf of that entity?
I am.
Are you familiar with the subject property that at 117 Pace Parkway that is the subject of this rezoning request?
Yes, sir.
Okay. Are you familiar with the history of that property?
I am.
Could you please explain what the history of that property was when it was initially developed with International Paper?
Certainly. When I first purchased the property, I spent a good bit of time with IP employees that had a history there, maintenance men that had been there for years, management people that had been in and out of there for years. That parcel was, the building itself, the first phase was originally constructed in 1978. 10 years later, the back portion was added and developed onto that. That housed their timberland divisions, that they ran their worldwide timberland divisions, had their credit union, their union hall. As you can see, it's got a parking lot that a capacity of almost 100 cars. There were up to 80 employees going in and out of that building on a repeated basis daily when they were in operation there.
Now, when that property was operating, how were they accessing the parking lot for the property?
It's only one access, Pace Parkway.
Okay. Now, that property is no longer being used for that office use any longer, correct?
That is correct. I've submitted a permit application to convert that to an assisted living facility on that portion of the property, yes.
Okay. Now, as an assisted living facility, will the usage for the access on Pace Parkway now be more, less, or greater?
The intensity will be substantially less. Those people don't drive.
Now, as far as the property to the east, the triangle piece, could you explain whether or not that property owner is favorable or objectionable to this rezoning?
Ms. Mary Moulton has, in fact, worked with me and looks forward to hopefully this taking place. That triangle piece there was originally the Cantonment Post Office. I went in there when I was a kid. That was the Cantonment Post Office there for decades and decades. They built a new building and moved. That parcel is still listed on the usage code under Chris Jones as vacant commercial. It is zoned LDMU, but Chris Jones has it. Their usage code is vacant commercial.
Now, could you describe the piece to the west?
Well, the blue that was that was up before is Gulf Power transmission lines. It's not an easement; it's a deeded right-of-way for high-powered Gulf Power transmission lines that come through there. Then on the other side of the Gulf Power transmission line, there's a 10-acre parcel that has several structures on it, the closest to mine being a 9,000 square foot structure, which has commercial operations going on right now, and is listed, the usage code with Chris Jones, as office and store.
Now, right now, do you believe that this is rezoned to be commercial, that would be a compatible use with the surrounding areas?
Absolutely. Actually, I made a comment before I submitted the application to one of the staff that I considered applying for HCLI because, and I had no idea that there would be any controversy about this. I'm totally blown away. I'm right across the street from a paper mill that HCLI might be more compatible because everything from Highway 29 to well past, a quarter of a mile and past my property on the other side is either industrial or HCLI.
Now, historically, based on your memories of that property that you described earlier, is it accurate to state that Muskogee Road corridor has now become a significantly more traversed and freight corridor?
Well, I'll even go a step further. I don't think it needs, but from the BCC meeting in March 5th of last year, Joy Jones' recommendation, I quote her, "This is a major local freight corridor that is key to expanding economic development in the region. Significant financial resources have been expended on this roadway to meet the increasing economic demand, enhance safety, and improve the overall viability of this corridor to handle the growing volume of freight and commuter vehicles." Goes on to expound on the number of grants, $3 million grant, 2.15, 1.9 million. Over $7.6 million been spent on that corridor right in front of my property.
To date, are you aware of anyone who, beyond the staff findings, that are opposing or have indicated any intent to oppose this rezoning?
Unaware of any, unaware. Nothing's been called to my attention. Had a great relationship with the neighbors across the street, had no issues.
That concludes our questions for Mr. Bowling.
Okay, thank you, sir. Do you have another witness?
I do.
Okay.
Our next witness is David Fitzpatrick, professional engineer.
Good morning, Mr. Fitzpatrick. If you'll please be sworn in and state your name and address for the record.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case with the truth, all the truth, nothing but the truth, so help you God?
I do.
State your name and address, please, sir.
David Fitzpatrick, 10250 North Palafox Street, Pensacola, Florida.
All right. Board members, you've previously, in previous meetings, accepted Mr. Fitzpatrick testimony as a professional engineer and expertise in this area. Do any of you have any questions about his qualifications or ability to offer that expert testimony? Okay. Well, he'll be entered as an expert witness as an engineer in the.
Thank you. And Mr. Fitzpatrick, if you could just give a brief overview of your experience, not for purposes of trying to deem yourself an expert, they've already done that, but just an overview of what your experience is for the board members.
I've been in business for over 30 years in Pensacola, attended numerous rezonings and variance meetings. I'm an active civil engineer in the community. I've worked with the staff for the past 30 years and with site plans and subdivisions and just basic civil engineering work.
Now, are you familiar with the 117 Pace Parkway property and the staff findings and rezoning requests that are at issue here?
I am.
Now, as to those findings that have been reached, one of the uses is compatible with the surrounding uses. And the conclusion reached by staff findings is that this rezoning is not compatible. Do you agree with that conclusion?
I do not agree with that conclusion. I've grown up in this area also, as Skip has, and it's pretty much a heavy commercial area, especially with the paper mill across the street. You look on the east side of 29, there's all sorts of heavy commercial areas there. The school that's just to our west is vacant and been used as a storage yard by the school board, I believe. So there's commercial uses in the area so I was kind of baffled as to why they came up and said that it was not compatible.
Now, isn't it possible that certain uses under the current zoning could actually create more intense usage of the roadways than some of the commercial uses?
Yes, the LDMU allows for restaurants, convenience stores, general stores, even in 35,000 square feet, commercial centers. So I would argue that you can have the same amount of traffic and use of the property as would be in the LDMU. In commercial, they pretty much go hand in hand.
Now, I've stated, and there's been previous statement by the owner about the decreased use with an assisted living facility. Could you provide your expert opinion on the impact or the decrease in traffic from changing it to an office use to an assisted living facility?
I haven't done the analysis in the ITE manual, but an ACLF is typically a low-traffic area, as a office building would have up to probably 80 or 100 employees come in and out of that building daily at lunch and dinner and God knows what hours. But I would say an ALF is much less impact than the commercial uses that could be in that building.
Is it your opinion that the conditional use that's now been approved would actually decrease the traffic on Pace Parkway compared to the prior use?
Yes, compared to the prior use, it would be less.
Now, as for Muskogee Road, would that be the main access point if development was done on the south end of the property?
I believe it would. Most engineers would look at that as being the number one place to enter and exit a commercial use of that property.
Would your opinion be that, consistent with the resolution in the Board of County Commissioner minutes that have been issued, that Muskogee Road is a substantial freight corridor relative to in the past?
Yes.
And for that reason, would rezoning to commercial be less of an issue in your mind as an expert based on concerns with traffic usage on Muskogee Road?
Yes, it would.
If it is rezoned commercial, would that create a transition point between the south industrial use of the property and the usages to the north?
Yes, in my opinion, the commercial use is a good transition zoning from industrial to MDR zoning.
Now, if you could provide some reference in your experience to explain what a transition zone is, why they're important, and your experience in how those are utilized throughout the county.
Just in my experience, you normally, if you do see an industrial use, you do see other businesses that need to come to the area to help provide service to the industrial use. So I'm not a planner, I'm an engineer, but in my past experience, the planners like to have the commercial uses next to industrial uses so that they can provide services to the industrial use and to the community.
Now, the conclusion reached in the staff findings is that this is spot zoning. Because of the transition nature that you just testified to, do you believe that conclusion of spot zoning is appropriate?
I do not, mainly because of the industrial use right across the street.
And by that, do you mean you've got a lower usage to the north, lower intensity usage to the north, and then obviously an incredibly intense use to the south, and that piece, by rezoning it to commercial, it is a transition between those two intensities?
Yes, that's my opinion.
Okay. Now, as far as the final category on changing use, changing circumstances, do you believe that the changes with Muskogee Road do create a change in circumstances where the argument in favor of commercial rezoning is actually increased based on the changes with that corridor?
Yes, I believe that does create a transition of use.
In your opinion, Does this rezoning request meet the 5 categories that need to be considered by this planning board?
Yes.
No further questions.
Thank you, Mr. Fitzpatrick.
For the next portion, would it be appropriate for the county to make their staff findings, and then Ms. Malone could make comment at that point? I could come up and question if necessary at that point, but logistically, if you're
Yes, you'll have opportunity to cross-examine any of the witnesses or information that the staff presents.
Okay.
So, yeah, we'll go ahead and do that.
Okay.
At this point, I'm going to ask that we take a brief recess. I have a commitment that I have to step out for. Mr. Pyle, as the vice chair, is going to take over and continue the meeting going forward. But we're going to take just a brief recess so that we can kind of transfer some information here for a minute, and also give everyone a chance to step to the restroom if they'd like. So we're going to take about a 10-minute recess, and we'll come back into order. It is 9:56. So let's just say about 10 after, we'll come back to order. So we're in recess.
Okay, if we want to call anybody out in the hall, I think we're about ready to bring us back out of, what is the session? Yeah, we're going to call this meeting back to order. We were at the point, if I'm not mistaken, for staff's presentation. Is that correct?
Yes.
Okay, go ahead and proceed.
Caleb McCarty, again, Escambia County. Of course, this is for the rezoning from LDMU to commercial, and we'll go through the criteria, and if any questions will definitely be available. Concerning approval conditions for criteria A, consistent with the comprehensive plan, we found that the proposed amendment to commercial is consistent with the intent, purpose of the future land use category mixed-use suburban, as stated in comp plan, future land use 1.3.1. The mixed-use suburban future land use allows for residential, retail, sales, and services, professional office, recreational facilities, public and civic, and limited agriculture. However, the proposed request would allow for more intense use and densities of the mixed-use suburban category that is not otherwise found in the surrounding area, as stated in CPP FLU 1.5.1. The property will utilize the existing roadway, utilities, and infrastructure, and encourages the existing development underutilized property to maximize development densities and intensities located in the mixed-use suburban future land use category. Concerning criterion B, consistent with the zoning district provisions, our staff findings find that the proposed amendment is consistent with the intent and purpose of the Land Development Code. The proposed commercial zoning may be established only within the mixed-use suburban and mixed-use urban future land use or commercial future land use categories. The district is appropriate to provide transitions between areas zoned or used as high-density mixed use and areas zoned or used as heavy commercial or industrial. The rezoning to commercial is subject to the same location criteria as any new non-residential use proposed within the commercial district. Pace Parkway is a local road and Muskogee is a collector street. The site is less than a quarter-mile radius from International Paper, which is located south of the subject property across Muskogee Road. International Paper is a traffic generator of more than 600 daily trips. Therefore, the requested zoning meets the location criteria as per LDC 3-2.10E2. However, even though the request meets the location criteria of the commercial zoning district as outlined, there is yet concern from our subject matter expert, Terry Malone, AICP, Escambia County Transportation Planner, that the proposed zoning on the subject matter property will have adverse impact on local residential roads. Following was provided by Transportation Traffic Operations in a memo dated 11/22/2021. 3 roads are associated with the site of the requested zoning change: Pace Parkway, Muskogee Road, and Pine Street. Pace Parkway is a 2-lane residential road approximately 20 feet wide with 10-foot travel lanes and no paved shoulder. Muskogee Road has 2 12-foot wide through lanes and turn lanes. Pine Street is a residential 2-lane road that is approximately 20 feet wide. Right-of-way width is 70 feet on Pace Parkway, 100 feet on Muskogee, and 52 feet on Pine Street. The county does not have any proposed improvement projects scheduled for Pace Parkway, Muskogee Road, or Pine Street at this time. Likewise, FDOT does not have any projects scheduled for these roadways. Pace Parkway and Pine Road are residential roadways with estimated volumes of less than 1,000 vehicles per day. The 2020 daily traffic volume on the section of Muskogee Road was 7,000. Primary concern is between the subject property driveway on Pace Parkway and Muskogee Road. This segment of Pace Parkway would be impacted by the higher intensity land use. As this roadway does not have sidewalks and therefore must accommodate pedestrian bicycle activity. Please note that TTO's review is solely based on the application submittal packet, so the comments above hold no bearing on any TTO comments made during the development review process. Concerning criterion C, compatibility with surrounding uses, we found that the proposed amendment is not compatible with the surrounding existing uses in the area. Within the 500-foot radius impact area, staff observed properties with zoning districts LDR, low-density residential, MDR, medium-density residential, and LDMU, and industrial. The parcels to the north and east along Pace Parkway and Pine Street or single-family residential homes and a church. The property to the west is split zone LDMU/LDR, and the current use is a church. The industrial zone property is located south of the subject property along Muskogee. The subject parcel does not abut any of the properties, as is surrounded by right-of-way to the north, east, and south, and a utility easement to the west. The southeast corner of the property abuts a property that is currently vacant and zoned LDMU. The Land Development Code defines compatible as a condition in which land uses, activities, or conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use, activity, or condition is unduly negatively impacted directly or indirectly by another use, activity, or condition. The rezoning would allow more diverse and intense commercial uses than the residential, neighborhood commercial, and industrial uses in the area. The proposed rezoning to commercial will encroach on the existing and well-established residential subdivision. The industrial zone property to the south functions as a paper mill and is an intense industrial use, yet has coexisted with the residential subdivision for many years. The uses of the proposed zoning district of commercial, such as retail sales and services, are found in the LDMU zoning district, yet not found in the surrounding zoning districts of industrial, medium-density residential, and low-density residential. A small adjoining property is zoned LDMU is currently vacant. Furthermore, the proposed zoning district would allow residential developments of 25 dwelling units per acre. The current allowable density of the LDMU zoning district is 7 dwelling units an acre. The increase in allowable density would significantly exceed the maximum allowed density of the surrounding zoning districts, as MDR zoning allows 10 dwelling units an acre, LDR zoning allows 4 dwelling units an acre, and industrial zoning allows only vested residential developments. Therefore, the permanent uses of the proposed zoning district are not compatible with the surrounding uses. It appears that the current zoning district of LDMU will continue to be suitable designation due to the surrounding uses and zoning districts. Continuing on to criterion D, appropriative spot zoning. We find that the requested zoning will be considered spot zoning as there is no other commercial zoning in the surrounding area. The proposed commercial district will be higher in density and intensity than the adjoining zoning. Therefore, the request appears to be inconsistent with the existing development pattern in the area. And finally, criterion E, appropriate with changed and changing conditions. Our findings found that the land uses or development conditions within the surrounding and on the site itself have not changed. The request appears to be premature for the area. The building on site has been utilized as an assisting living facility and office in the past. It currently appears to be unoccupied. In April 2017, the subject property received conditional use approval from the Board of Adjustment to allow an assisted living facility in the LDMU zoning district. That concludes staff findings at this time.
Thank you. This time, the only public speakers we have, I believe, here have already spoken, both the attorney and the applicant themselves. Are there any other members of the public here who wish to speak on this topic? Seeing and hearing none, I'm going to move on to any board members have any questions?
Vice Chair, I have a question and a comment. The question is, how large is this parcel? And two, I noticed that we've taken the parcel sizes out of our packages. Is there a reason for that?
I'm not aware of the heading was or wasn't available, but it's approximately a little over 7 acres, I believe. 7.4. Yeah, so.
We'll have an opportunity to cross.
At the end, yes, sir.
I've got a question, Chair.
Go ahead.
In 2015, we changed our zoning. In looking at the uses of this property and the property to the west of it, was LDMU pushed was the right zoning when it was changed in 2015, or would it should have been commercial in the beginning? And
we could find that out, but But basically, if it was on LWU, it wasn't like it had to be an R4.
Can you do your mic?
Thank you, thank you. Yes, Horace Jones, director. If it was, if LDMU was chosen, and we can verify that very quickly, it was chosen because of the existing zoning category, and we just merged that zoning category with this one. So we can find out that, yes, so it was village mixed use too, so that was a light, not a light commercial, a light mixed use area that would allow for limited retail uses, not heavy commercial. That's what village mixed use back in the old code. We can prove it. I can show you the exact things, but I've been here a long time, so I got good familiar. So it was nothing more, nothing less. It was retail, neighborhood type uses. That's what VM2 allowed for back then, and that's what low density mixed use allows for now.
So if you look at the property to the immediate west, which is the 9,000 square foot building, or whatever that square foot building is, along with the office that was previously used in the post office that was previously used, all of that would have qualified for the VM2?
Yes.
During that time?
Yes, sir.
They wouldn't have been extenuating circumstances where they should have been grandfathered in because of use?
They could have been, but again, if it was a retail, and I think that was said retail neighborhood, that's what VM2 allowed for back then. Post offices, that's what neighborhood type uses allowed for then. Now there could have been some other use that was grandfathered in, but as far as the particular use, yes, sir, that use would have been consistent and merged into low density mixed use, clearly.
Thank you.
Yes, sir.
So it's safe to say, and for the applicant, I get it, but I think back in the day, it's a great question, Reed. Back in the day when we made this substantial change to the overall zoning categories, this is the byproduct. That's why we are here and have this lovely job today, because a large net was cast. And I'm not throwing rocks at the planning, but I see it, it's obvious probably to you guys too. It's like time didn't happen before that. Nothing ever occurred. We have to throw away history. We don't, because it's our job. Their job is very black and white. They look at the surrounding, hence the rub where it seems as though it's totally opposite. Again, back to the attorney's statement, this is transitional, and that's where we have to, I guess, use the 6 inches between our ears to figure this thing out for them, or help along with the public input. But one of the things that caught my attention, and Mr. Brisky as well, was that the usage category for that building that is shown up on the tax assessor's records, it's the usage, not the zoning, was labeled as commercial, which for any of us, anybody in the public, that would be, I would probably grab that as part of my argument as well. But is that fair to say that that may be a dated or type of a terminology that
Yes, sir, I think that's a terminology, okay. Because see, when you look at retail, basically most people gonna consider retail as commercial. However, there are different types of retail that is more neighborhood friendly. Then there are commercial type of retail that is more allowed for commercial. So just because that's why we don't go by the uses classification as for zoning. Just because a commercial, people gonna say it's commercial, just commercial because you got, but it could be limited type of commercial, which were more inclined, just to answer your question, more retail oriented toward more neighborhood type uses, in which that old zoning category of village mixed use would allow for. So it was nothing that we missed anything, it was consistent, we just merged it together, because we could not downzone no one. We would have been in trouble.
Right.
But we had to take them and consolidate zoning categories and change the name, and that's what we did for that village mixed use too. And we just call it low density mixed use.
Right. I get it. We're not necessarily throwing rocks. It's just, this is going to happen, and it's going to continue happening. But one question for staff: does HDMU allow for a assisted living facilities? Just a question.
Yes, I believe it does. It does allow for, you know, they're a little bit more intense than the LDMU, but we can.
Yeah, just a question. Are there any other questions?
And this is the thing I want just for more clarification, just for more. Now, conditional use approval did allow for, and it does. He got conditional use approval to allow for that assisted living facility. So therefore, they can proceed with that if they want to, if everything is still intact with the timing, because it was a few years ago. But they can proceed if that's again, we don't look at uses per se, we look at all of the uses. And that's what our findings were based upon, all of the potential uses. So if you want to proceed with low density mixed use, he authorized to proceed with that, and that won't be, because the BOA granted that conditional use approval. There's no rezoning that would be necessary if everything is still intact with the timing. And we do have avenues to address the timing aspect for those, just to clear the record and on that. That's all I just want to say.
Understood. And again, we preach it that we don't ever look at the potential use, but what's good for the goose is good for the gander. The applicant also paid good money to make this change, and they're certainly more than able and allowed to change it, or at least attempt to change it. If there aren't any more questions from the board members right now, I don't want to forget our staff member and the board, the transportation expert. I think we had a question on the table regarding the definition of the freight corridor, if that was the right terminology. Could you come up and help us, enlighten us? And I'm sorry, I didn't catch your name. I apologize.
I'm Terry Malone.
Okay, thank you.
Hit the button.
Sorry.
They got you. They got you.
Now it's on again. Okay, I'm Terry Malone with Traffic Engineering. So the question about the freight corridor?
Yes, ma'am.
It was an official.
Should be sworn in or not?
Sure, absolutely. We are.
Were you in the room earlier when
if you raised your
staff
hand
was
during
sworn
staff?
in?
Let's go ahead and
believe I was,
swear
yes.
in to be safe.
Keep it straight.
Yes, I do.
And Terry, if you could, your name and your position and address as well, please.
My name is Terry Malone. I am the transportation planner for Escambia County, and my address is 452 Woodbine Drive, Pensacola.
Terry is with an I or a Y?
I.
So the question at hand was apparently, and part of our submission.
Was just the change in circumstance and the freight corridor. We were establishing an already existing freight corridor. Just making, and what a freight corridor stands for is usually is where you'll have high volumes of heavy vehicles traveling up and down the road. Now, that has been the case with Muskogee Road for quite a while. And what we've got the grants for was for widening the road, repaving the road, making sure that you have two 12-foot lanes. That is really part of what's going on with the freight corridor, is you accommodate the heavy vehicles a little bit more with some subgrade, some extra signage, some markings throughout there, a little bit of lane departure safety enhancement, whatever we can do within the right-of-way.
And I'm in my mind picturing all the large semis with the lumber in the back, along with all the associated traffic with that. And I think that's what the applicant was trying to establish, was the fact that this has been a heavily traveled road in that regard. And I guess those funds could be used for the repairs, for the
repairs, the widening. It has to be 12. It was not consistent all the way through Muskogee Road to have it with lane widths of 12-foot wide. So we had some 10-foot sections. That's really not very good for heavy vehicles. I don't know whether I'd call it a change in circumstances. There's no, future, Ms. Jones said about about how future economic growth, that's what we are anticipating. But that's not what's going on here, is we're just trying to accommodate the freight, freight going through here in a safe manner. We are working towards, the state has a zero tolerance rate. We're trying to, get down to accidents, crash levels of fatalities of 0 fatalities. So we're doing everything we can to enhance the safety along the corridors.
Makes perfect sense to me. I don't know if the applicant's attorney would like to ask her any other questions.
Just a few.
Okay.
And this is just for the transportation issue. We'll let you again come back at the end for any rebuttal after we ask for the staff any other remarks.
You referenced freight corridor. I just want to be clear. The memo that's included in the packet, it didn't make any reference to freight corridor, correct?
No, my concern was not towards Muskogee Road. My concern was towards Pace Parkway. That section that you would have a driveway that gets out to Pace, from Pace out to Muskogee Road, that would be my concern. And my concern is not because of increased traffic volume. My concern was because that corridor does not have sidewalks on it, and so you have to accommodate more than vehicles. You have to accommodate pedestrians and bicycle travel through there. And then, as you know, if an elderly person is walking along, their reaction time is a little bit slower. So you want to have, you want to have ample room, and you don't want to increase the traffic on that section of roadway.
But my questions are focused on the absence of your memo. Your memo does not reference the freight corridor, correct?
That is correct, but it does say that it has
Thank you.
7,000. That was never any issue.
Right. And your testimony was it was a high volume of heavy vehicles. That was your description of what freight corridor means. Is that correct?
Anything over 2% is considered a heavier volume. I don't know what the actual volume is on Muskogee, but it's public record.
I'm merely repeating your words. You said it was a freight corridor was a high volume of heavy vehicles. Is that correct?
A high percentage of vehicles. You can have a low percentage road and you still have a high volume of vehicles compared to the rest of the traffic. The ratio is different than on a residential roadway.
That reference and high volume of heavy vehicles or any ratio, that's not mentioned anywhere in the memo, correct?
No, because that is talked about as a road that is okay.
Okay, thank you. And so do we have any other comment from staff?
Not at this time. I would just say this it's a tough case in the fact that when the main thing of our analysis when we looked at this is the surrounding uses. The LDMU we found, and it's noted in a brief description of our findings, LDMU fits. It works here, and that's what it's designated on, and we didn't find any issues there. It's that next step. It's the next step up that we didn't find comparable uses. We didn't find compatible uses of what otherwise would be allowed in the commercial zoning district. That's the analysis in summary, and we're available for any questions on that, but we just didn't see it in the area.
So the address is 117 Pace Parkway.
Yes.
Is there currently a curb cut off of Muskogee to this parcel?
I'm not sure. I don't think there's a driveway going onto Muskogee from the parcel itself. I think the access is off of Pace Parkway. I mean, it would appear to be where the assisted living facility is. I think that's where the driveway is at right now.
Is Pace Parkway the only curb cut onto this parcel from a county street?
That's all I see. That's all I've seen concerning access. There is a site photo of that we took when we were out there. Rachel, if you bring that up, I don't think there was actually. This is the.
Can I ask how y'all got inside and take that picture?
Sir, just please hold. We're in a quasi-judicial. I'd rather not have anybody burst out while we're talking. Thank you.
This is the driveway from the public right-of-way off of Pace Parkway. That's the only access that we saw.
Thank you.
Mr. Chair,
Yes, go ahead.
I just want to get this clear. With the zoning it has now, they can have the assisted living facility right now?
No, with a usage, they were allowed a special usage for it.
Oh,
It is
special
not currently
usage.
under that zoning. They were offered a conditional use only.
Well, let me ask you a question about that, and this just, in my mind, I don't think it changes how I feel about things. But as I recall, didn't I hear you say that they went through a variance process, and they got a variance that sticks with that property forever, pretty much? Now, you said it differently, but that's what I think exists.
It's not a variance. The conditional use process through the Board of Adjustment, it was approved for an assisted living facility.
Okay, so does it stick with the property forever?
No, it has a valid period at up to 4 years. And I believe they're in the process of applying for building permits and things such as that. So it's in the works.
Thank you. That clarifies something for me.
So this is one of my challenges for staff and Horace. This is where we always run into the rub, the transition. Obviously, when International Paper was built, this was like a village, or whatever you want to call it. They obviously had transitional. They were smart enough to think that, hey, we need to have residential, homes nearby. This was obviously built. We can't erase the fact that the building is there, nor what it was utilized for in the day. However, unfortunately, with staff's very rigid, and I understand completely why they're rigid. They have to look at the colors of the boxes and say, well, is it this, or that? Therefore, I don't see anything compatible. Transition's the key here, where we're having a challenge allowing something to transition. So, and I'm just, in my mind, considering this for future references, but, how do we? Otherwise, we don't ever make a change.
I can tell you how. Just answer your question. There is another zoning that comes after low-density mixed use, which is called high-density mixed use. Then you proceed to commercial. So there is another zoning category that's step above. So if, to answer your question, you can go to the next level, to the next level of that. If you want to transition, just because you are skipping over another zoning category to go to a commercial. So if you want to transition, you transition by going in steps, if that's to answer your question directly.
Right, and I would agree if it wasn't such a radical difference to the south in industrial. It's a massive change. So
what we did find, and what's interesting enough, is within surrounding zoning districts, such as MDR and LDR, of course, they don't allow retail sales or services in those commercial. The LDMU does, and that's what the property zone is. What's interesting is that the industrial zoning doesn't either. Even though it is industrial zone and it's International Paper, it doesn't allow for those commercial type uses. And that was fundamentally why we really couldn't say that that next step up really wasn't appropriate. And that's what we found. So. And this is why
we bring this case before the board. We just present the facts. We just present the facts. And if you all see that things are different from us, we just present the facts. You all make the recommendation, then go to the next step. We have to look at the black and white nature of the Land Development Code. We have to, and that's what we did in this case. And it's up to the applicant and their attorneys or whomever to present your case. Then you all make the recommendation, and if it proceed to the next level, the board has the next authority. So if you all see gray, you all have the discretion. But we got to present the black and white language of the code.
Understood. Anything else from staff? The applicant, you have anything else further to say?
Yes.
Come forward.
If you could put the zoning map back up. And may I proceed with questioning at this point?
Sure.
Caleb, for that picture up there, isn't it correct when you're talking about that one incremental step? If you went from the south portion of the property where it's industrial, that would be heavy commercial, light industrial, correct?
Maybe. It's separated by Muskogee Road. That's a significant right-of-way. That had to be taken in consideration, but we can't necessarily say that next step would be heavy commercial, light industrial.
Well, let me stop you there. The other uses are separated by Pine Street and Pace Parkway. So all
Correct,
these
yes.
uses are separated by a road, correct?
They are, yes, sir, we agree with that.
So
yes,
if you
sir.
go from the south and you drop down one usage in intensity, you're now dealing with heavy commercial, light industrial, correct?
Yes, from the industrial zoning district, yes.
Now, if you go up from LDMU up one category, then you're high-density mixed use,
Correct, yes.
The one in the middle, regardless of origin of whether you're talking the
Right.
south or the north, is commercial, correct?
That's right, yes, sir.
When we walk through that logic, do you agree that commercial is probably the appropriate transition zoning based on what I just described?
It's the residential neighborhood that surrounds it. When we did our analysis and we have that swath there, the 500-foot radius, it grabbed the majority of residential uses. Both of those, the industrial uses is separated by the right-of-way as well. That is a higher classification of road than the industrial property.
So is that the reason why you think it is spot zoning?
It would be spot zoning in that there is no other commercial surrounding it. We do have transitions. LDMU is somewhat of a transition zone as well. And we just felt like the designation of the property was the most suitable. It's been that way. There is the next step up would be high density. Again, that swath that grabs the residential uses is what was taken in consideration, along with the industrial to the south.
Would you agree that the transitions are important?
Yes.
Okay. And would you agree that commercial would be a transition?
And the intent of the commercial district does allow for transitions. However, it allows for a transition of high-density mixed use and the more heavy commercial light industrial. We didn't find any of that there.
Because of the fact that it is, since commercial is transitional, that would not be spot zoning, correct?
It's possible, but that really, the definition of spot zoning is fairly clear. It doesn't abut any adjoining properties that have the same zoning district. That's, yeah.
So you view that as black and white?
We have to sometimes, unfortunately, in our position.
Could you pull up the zoning for the three that were approved before on 2015?
We're going to stick, I think we need to stick to this case. And
What-
I think
but-
we need to stick to this case.
But it's
Again,
for-
now remember, the staff has made their findings, and the argument is made before the board. I don't think we're going to have a big moment where the staff's going to break and say, we've changed it. They've issued their application. You've acknowledged that you received and approved that application. We're just here to determine whether your argument's enough to sway the board to go forward or not.
And Chair, if
My-
I can offer, as far as criterion D is concerned, the staff decides spot zoning. The burden we bear is
That's
the
correct.
words appropriate if. That's that gray
That's
matter
correct.
that, as you said, we have to use the
That's
6
correct.
inches between our ears
correct.
to
So again,
determine if
the
it's
burden's with us.
appropriate.
It's not really to change staff's mind or opinion.
The
And we-
reason why
Go ahead.
is the definition of spot zoning, those parcels are approximately 3.5 miles away. They're on CR 184. It's not Muskogee Road, but if you track that state road,
Right.
there was a determination made on spot zoning, which if you apply that definition
But
there.
their world revolves around 500 feet, and that's where it becomes black and white. Hence the red circle around what the issue at hand is. And that's their criteria.
Correct, but I'm applying it from the standpoint of, if you look at usages that are around that transition issue, but essentially, if you applied the logic that came up with the staff findings on those three cases, you cannot apply that same logic to this. It is the opposite.
But they've issued it. Now, again, it's up to us. We hear your question. I appreciate the argument. We were going to have to, consider that in our determination.
It's noted.
So-
Can I just be clear further?
Sure.
Your determination is that evidence is not appropriate, you don't want to go in that direction? Just to be clear.
I don't think that the previous cases are relevant. I understand your point. It's bringing up your argument, and we duly noted. We appreciate it.
Well, no, but I'm wanting to show the zoning map. I don't intend to go into the actual findings of that other case.
If
Merely to-
I may, in much respect for you, each case has to stand on its own merits. That we do not want to get back to those cases again.
We get it. He's not trying to
Yeah.
open it up. He's trying to bolster his argument because of the location. But all the location criteria are the same, and/or the spot zoning, all done within 500 feet. That's where their world stops and starts during the rezoning consideration.
Okay. I understand. Could I have one point on the evidentiary issues, just to do some housekeeping?
Go ahead.
Because you had made the point on the property appraiser page
Yes.
for that east parcel.
Correct.
And for the west parcel, both which indicated the reference to the commercial use. Could we have that, basically the property appraiser printout for those two parcels added as Exhibit 3 and 4?
We have no issue with that.
And that's what I'm asking.
So did you just have that pulled up?
We can extract it from the
Okay.
property.
I can email it afterwards.
That's at
Yeah,
the,
that's
at
no
the board's
problem.
pleasure if somebody wants to make a motion.
And I would concur that that's indeed, that was looked at, and that's indeed the classification for the adjacent property.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye. Aye. Any opposed? That will be issued as, I believe, document number 3. Yes. Exhibit 3, excuse me. Okay, sir, you have anything else?
No, but the remainder of mine is going to be closing arguments, but I can.
We're there.
Okay.
We're there. Go right ahead.
We've gone through the different criteria, and one of the points that I raised with Ms. Malone was not to challenge some of the complexities of it, but to address the fact that when you look at the staff findings, the freight corridor and the volume aspects, we're not actually in there. I mean, for a lot of the reasons you've already explained, you have to fit things that don't neatly fit in a box because of the prior history. Now you're trying to basically go back and correct without the easy ability to have a consistent manner of doing zoning from the beginning. That's what we're limited by. But when you look at this property and what the testimony has shown on what the original use and development was, this isn't out of line. And that transition is the key. If you were going to find that middle ground where either you're going to go one intensity down from the south usage, which I don't think anyone wants to put heavy commercial light industrial, or one step up, which would be the high-density mixed use, that commercial is the middle ground. And that's consistent with what the prior use of the property is. And, you know, for that reason, it's a valid rezoning request. It meets the criteria, and the only criteria that staff have made the conclusion don't apply are the more subjective ones. And when we've gone through the testimony, which includes David Fitzpatrick, about the importance of those transitions, some of the comments you've already made on the importance of those transitions, that for that reason, a commercial rezoning is appropriate. And, you know, this is quasi-judicial in nature. Transparency is important. One of the reasons why I went through in detail on the staff findings is they primarily are based in conclusions, not actual analysis. And when we put forth our evidence about what that history of the property was by someone, you know, the principal of the owning entity, as well as David Fitzpatrick, it complies with those requirements. Those 5 criteria have been met. And I think the key is the transition. There's no use there that's going to change or damage that residential subdivision that wasn't consistent with what it was from the very beginning. And the fact that there's no one here from the general public arguing against it, I mean, we've all been to those ones where you got, you know, 10 people behind you who are ready to stand up and object to it. In this case, the only parcel that actually touches it is actually in favor of it. And there's no one from that subdivision who's complaining. For that reason, we would request that that rezoning be granted to commercial. Thank you.
Thank you, sir. Appreciate it very much. Before I entertain a motion, or be willing to entertain a motion, I'll just ask our attorney, we're putting you to work today, if the motion is in favor of applicant, is it acceptable to say that in the form of that motion that that we have found the argument enough to proceed forward, or do we have to hit each of those 3 criteria that were found by staff to be not in compliance? Do we have to go through each of those and say that in that case of C, we find with the applicant, D, we find with the applicant, E, we find with the applicant?
I think for the purpose of just a clear record, it would be helpful to go criterion by criterion and say whether you find for the applicant or against the applicant.
Okay, great. And so, again, having no clue what's going to happen, I would ask if you guys would bring up the criteria again, just for the sake of the ones especially that were, not found. All right, at this time, Chair will entertain a motion. Give a little time if you want to get your thoughts together on this one as well. It's a challenging one.
I'd like to make a motion to approve, I'm trying to remember what number this is. Z21 18. And regarding criteria, sorry, I'm scrolling through. Criteria C, compatible with surrounding areas. I agree with the applicant that it is compatible with surrounding areas. Criteria D, appropriate for spot zoning. I also agree with the applicant that is not considered spot zoning and is a proper transition. And I believe criteria E is already approved. The items, the findings have not changed. So I would approve with those recommendations.
Second.
I have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed signify by saying nay. Hearing none, it passes. At this time, we have one last case that we will have to do a little housekeeping. At this time, I'm going to put the quasi-judicial rezoning meeting in recession while we go to our regular planning and board meeting for a small-scale amendment that is required to be heard prior to this case. And if you will bear with me, this meeting of the Escambia, this meeting of the Escambia County Planning Board for December 7th is hereby called to order with 7 members. We do have a quorum. Ask the staff, do we have proof of publication for this meeting?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
Chair will entertain a motion to waive the reading of the legal advertisement.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye. Aye. Any opposed? All right, the motion passes. The planning board meeting minutes for this day has previously been provided to the board members. The chair will entertain a motion to accept the planning board meeting minutes into evidence. Do we have a motion?
Moved.
We have a second.
Second.
All those in favor, please signify by saying aye.
Aye.
Any opposed? Motion passes. The planning board package for December 7th has previously been provided to all board members. That's Chair will entertain a motion to accept the planning board hearing package and the legal advertisement into evidence. Do we have a motion?
So moved.
Do we have a second?
Second.
All those in favor signify by saying aye.
Aye.
Any opposed? Motion passes. We go into the agenda for this. We'll hit, I would like to go to the public hearing. Number 1, a public hearing concerning the review of an ordinance amending the future land use map SSA-2021-08. Staff, who will be discussing that? Thank you, ma'am. Go right ahead.
Okay, so I guess we'll do our maps and photography.
Yes, please.
Okay, this is the location map showing the site on Pine Forest. This is the current future land use of mixed-use urban. This is the proposed future land use of public. And this is the commercial zoning, showing the commercial parcel as commercial zone. And this is the aerial photography showing the wetlands, which is stormwater ponds. This is the public hearing sign posted on Pine Forest Road. This is looking into the site from Pine Forest Road. This is looking south along Pine Forest Road from the subject property. This is looking west across Pine Forest Road. Looking north along Pine Forest from the subject property. This is the public hearing for the future land use sign on Pine Forest Road. And these are this is the public hearing sign for the future land use and the upcoming rezoning on Godwin Lane. This is looking into the subject property from Godwin. And this is looking onto the site, just another view from Godwin Lane. This is looking west from Godwin Lane toward Pine Forest Road. Looking east from the subject property along Godwin. And that's the maps and photographies, if you want me to go with the staff analysis. Yes, please. Okay. So the location is 6722 Pine Forest Road, and they are requesting to go from mixed-use urban to public. So this is a small-scale map amendment, and as you recall that not too long ago, the state required, instead of 10 acres, it's 50 acres for small scale. So this is a proposed change of 30.89 plus or minus acre parcel from mixed-use urban to public. It will be compatible with the request to rezone from commercial to public. The applicant's plan is to add a solid waste transfer station to the existing waste management facility. Currently, the site has an administrative building, warehouse, maintenance facility, and parking for the collection vehicles. The current mixed-use urban land use category allows for a mix of residential and non-residential uses with a maximum density of 25 dwelling units an acre and a maximum floor area ratio of 2.0. The requested future land use to public allows uses of facilities owned or managed by federal, state, or county governments or other agencies with no residential allowed. So in order to meet the small-scale map amendment requirements, this particular project did meet all the requirements. It's a subject property that's 30.89, which is under the 50 acres. The proposed amendment did not involve a text change to the comprehensive plan, but only proposes a land use change to the future land use map. And the properties of the subject are, excuse me, are not within a desired area of critical concern, and the change maintains internal consistency between the elements of the comp plan. So for the existing proposed future land use and the existing and proposed future land use, the mixed-use urban allows for a mix of residential and non-residential uses, including retail services, light industrial, recreation, and limited agricultural. For the public future land use allows for facilities and uses which are owned or managed by federal, state, or local governments or other public agencies, and the uses include public parks, local, state, or federal facilities, and no residential densities. For the land use map amendment requirements, the analysis for a conversion to the public would provide a current facility to upgrade by adding a transfer station to maximize their efficiency, and will allow the current facility to expand and support the densities and intensities of the uses in the area. For the comprehensive plan objectives, for the housing and the future land use designation, mixed-use urban is the current future land use for much of the land on the east side of Pine Forest Road, with a combination of residential, mixed-use, and commercially zoned properties. Therefore, the addition of a transfer station on the existing ECUA site would increase the efficiency and minimize their cost. For infrastructure, the site is located on Pine Forest Road, which is an arterial roadway, and has been a garbage and transfer station since the 1980s. The site will continue to provide services to the growing residents and commercial uses in the area. For the potable water, sanitary sewer, and solid waste, the Emerald Coast Utilities Authority, it does provide the water distribution, sanitary sewer, and collection, and solid waste to the parcels in the area. Therefore, the addition of the transfer station would be beneficial. So for stormwater and transportation, the site currently has a stormwater pond, but the applicant stated that there will be an additional pond which will be reviewed at the time of the site plan review. And the traffic and transportation staff has provided comments on the amendment request, and there were no significant projects for this area that were stated. Based on the Escambia County GIS, the subject parcel is outside of a wellhead protection area. And for historical significant sites, there were no identifications that any existed on the site. And also for wellheads, wetlands, there's no indication by the National Wetland Inventory Map that wetlands were on the subject property. However, this will be reviewed when it gets to the site plan review process for the addition of the transfer station. And that concludes the staff's analysis.
So regardless of anything that occurs, this small-scale amendment would be required, is that correct?
Yes, sir.
Any questions from the board for staff? And I want to ask, do we, in the agenda, I don't have later on in the planning board, I have public input. I have speakers for the quasi-judicial and the rezoning, however, not on this particular, this case, but this is more of a housekeeping.
Well, the ECUA is also, they have representatives here to speak on their small scale also. I think they're here more for the rezoning, but they can, if you want them to speak.
That would be great. I'd love for the ECA to come up and, in layman's terms, tell us what you want to do.
Yes, sir. DeWitt Clark, General Counsel for ECUA. I have Mr. Bruce Woody with us, who's our Executive Director. He's available for any clarification. No? Speak up. Okay, sorry about that. DeWitt Clark on behalf of ECUA, General Counsel. I have Mr. Bruce Woody with us, who is our Executive Director, who can speak on any questions y'all might have of him outside of staff findings, if you need any clarification.
So back to staff's findings, we need to have a small-scale amendment in order to even entertain anything from this point forward, correct?
Yes, sir. So if they, in the quasi-judicial, they have a rezoning request. In order to do that, they have to change the future land use map to be consistent with their request to rezone.
Which would require a vote and a motion and a vote for approval to recommend to the Board of County Commissioners, correct?
Yes, and this doesn't have to go to the state because it is under the now 50-acre minimum. It'll
Okay.
just go to the Board of County Commissioners.
Board members, any questions? I am ready for a motion.
I move that we approve small-scale amendment 2021-08.
And Mr. Chairman, just before you take a vote, I just want to be clear, there was no.
I didn't have my speaker on. I was trying to read it, and everything's blurry today. I move that we approve SSA-2021-08.
And just to be clear, I want to make sure that there were no members of the public that signed up to speak before on this specific item.
There are not, these are all for the zoning case.
Okay.
I have rezoning case. Now, rezoning case.
I just wanted to make that clear for the
Rezoning
record
case.
before we moved on.
Yeah, and so, and I'll make it clear to the public, these are, all the public speaker forms were filled out for the rezoning case. If you wish to speak, this would be the time, if the public had any input on the small-scale amendment. Hearing none, we have a motion. Yes. Ma'am, if you'll come forward to the microphone.
As long as they know this is for the small scale and not the rezoning.
This is for the small-scale amendment. Horace, do you want to try to clarify what a small-scale amendment and the reason for having that?
Yes. The purpose of this microphone, thank you. There will be another opportunity to speak. You can speak on this if you desire to, but the purpose of the small-scale map amendment, the state says when we do these zoning and future land use category, we got to have consistency. Everything got to match up. So this part of the same property You still gotta go through the same process as far as meeting certain criteria. We just basically, at this process, the board is just trying to say, yes, if they decide to do it, it will need the future land use change right now. Now, we're not directly getting into the compatibility of the area now in this process. We're getting into more critical infrastructure needs in this part of the process, like if sewer's available, if potable water's available, if they got connections and things like that. And this is the same parcel, but this is a different set of requirements that they got to meet right now, because we got to have consistency in it, and this part got to be done first. So you will have another chance to speak. You can speak at this, but if you want to wait until the next part of the hearing, you sure can. And that's
Well, I understood that if we didn't speak today.
yes, that's the next. That's coming immediately after this.
That's right. So ma'am, in the other, once we get this bookkeeping done, we go back into, we will hear the case, and that is what's called the quasi-judicial. It's almost like a hearing in court of law, and that's where you'll have the opportunity to speak either for or against, and that's where it's also, the gentleman here will be taking notes, and it's entered in the public record, and therefore, at a subsequent meeting, if either pass or failure at the Board of County Commissioners, you will then be authorized and enabled to speak at that meeting because you spoke here.
Right.
But not at the small-scale amendment level. You're welcome to speak at it. We always want people to be involved in it, but this is more of a, we have to do this to stay in line with the state regardless of what happens next in the rezoning.
Okay, well, we're here because we want to object to the rezoning.
Well, we'll get you in the rezoning then, if that's okay with you.
Yes,
Okay.
yes.
So I'll just wait until.
Yes,
the
ma'am.
next part, yes, ma'am.
Okay, thank you.
So, thank you, sir. I'm sorry I didn't do a good job clarifying this. You're
You
getting.
did. It's just you did.
So, we have a motion on the floor. I don't know if you want to repeat it, Mr. Sammons. You probably don't, but I'll ask you to.
I will. I move that we approve small-scale amendment 202108. And I turned the mic on that time.
Second.
All those in favor of going forward with this, please signify by saying aye. Aye. Any opposed? Hearing none, it passes. At this time, I'd like to put the regular planning board in
Excuse me,
session.
Mr. Chairman.
Yes, go ahead.
We've had a request by the next applicant on this public hearing for Wildwood Estates. If they had to get pulled into another meeting, if they could knock this out real fast and then jump back into their meeting upstairs. They don't think it's going to take much time, but they just.
We okay with that, sir?
I do believe. Yes, I believe there should be some members of the staff that will give the background to this board. So once they get here, this board could move forward.
So can we get staff here so we don't have to wait? Yeah, let's do it. Let's get it done and get it done with so that we have, I mean, I understand we all have time constraints, myself included. However, that's probably going to be thrown out the window today. Okay, we're going to proceed with the next public hearing, a public hearing concerning the review of a development agreement for Wildwood Estates. I don't know who on the staff is going to present for that. Are they here? Are they present?
It was a
We
legal.
don't-
It was a legal document. So
Okay. Go ahead, sir.
Mr. Chairman, this is before this board on a amendment to a development agreement. It's my understanding this development agreement has previously been amended. This is more of a housekeeping matter before it goes to the Board of County Commissioners. The it's my understanding this agreement has been negotiated between the parties and the county would be asking that this be approved before it goes, or recommended for approval by the BCC as a whole. Of course, this board, its recommendation can either be for the BCC to approve the development agreement or the amendment, to deny it, or to approve it with certain changes. Of course, if changes were recommended, the other party would have a say in that as well. So the vote before this board today is approve, deny, or approve with recommended changes.
And if I may, I'd like to add, and because this is a legal document, it has been vetted thoroughly by our legal departments, by both attorneys and our legal team, legal department. So it has been vetted, and I believe that legal has signed off on it, saying it met all of the statutory requirements for a development agreement.
So if I'd like to throw my layman's terms, because the other folks up here are probably smarter than I and won't reveal, but my layman's translation of what happened, it's more of a timing issue, that development agreement was entered into a long time ago, and we'd like to basically update it. Is that correct? I want to bring it down a notch. I'm not the attorney. I'm nowhere near it. So that was my understanding reading it prior to showing up here. I want to make sure I'm on the same page. So that's what we have before us. I don't know if the applicant needs to present a case.
They do not need to present one, but of course, if the board has questions, they could make those to the applicant.
Board, do you have any questions regarding this? Hearing none, I'll be glad to entertain a motion.
Motion to approve.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? None heard. It is approved, recommended to the Board of County Commissioners that this proceed as it is written up. Now, at this point, I'm going to put the regular planning board meeting into recession and go back and call to order the planning and zoning, the rezoning meeting, and bring back case, let me get this right, Z2021-14, and ask who on the staff gets to present for this one. Congratulations. If you'd like to, well, first of all, I've got some other issues to do here. All right. First of all, I need to go through any members of the board. Has there been any ex parte communication between you and the applicant or the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? Please also disclose if you are a relative or business associate of the applicant or the applicant's agent. And I would like to remind us that we are now in a quasi-judicial meeting. So I'll start down at the end, sir.
No to all.
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 All right. Staff, was the notice of the hearing sent to all interested parties?
Yes, sir.
Was notice of the hearing posted on the subject property?
Yes, sir.
Staff, if you'd like to, please go ahead and present.
Okay, we'll do the maps and photographies, and then the applicant will do their presentation. So, again, this is the location map for the Z 2021-14. This is the future land use map showing mixed-use urban currently. This is the zoning map showing the commercial and the surrounding HDMU, MDR, and across HCLI. This is the existing land use showing the parcel surrounding the subject site. And this is the aerial photography. And this is our rezoning sign that was posted on the Pine Forest Road side. This is the entrance to the ECUA on Pine Forest. And this is again looking south along Pine Forest from the subject property toward Godwin. This is looking across the street, Pine Forest from the site. That's the Walmart across the street. This is looking north along Pine Forest Road from the site. And this is the public hearing sign that was for the future land use case. This is the public hearing sign that was posted on Godwin Lane for the rezoning. And this was looking onto the subject site from Godwin.
as well as this also just showing a little bit more of the western side of the parcel along Godwin. This is the parcel showing the, on Godwin looking west toward Pine Forest. And this is looking east from Godwin. So that's all our maps and photographies, if you'd like to have the applicant, and then I can do my analysis.
So if the applicant please come forward. I don't know if the applicant needs to be sworn in as an attorney. Do not. Please state your full name and address for the record, please.
Yes, sir. Thank you. DeWitt Clark, General Counsel for ECUA. 40, I'm sorry?
Go ahead. Your address, I'm sorry.
40 South Palafox Place, Suite 300.
And have you received a copy of the rezoning hearing package with the findings of fact?
Yes, sir, I have.
And do you understand that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
Yes, sir.
Please proceed.
Yes, sir. Thank you. We've received the staff's findings. Now that we've amended the future land use map, we meet all of their requirements. Or I'm sorry, we have staff approval on all of the categories. What we're seeking to do here is a rezoning to public to allow for a solid waste transfer station, which I believe earlier you requested that in layman's terms. Basically, it's where this is a site that's already used for solid waste, trucks, vehicles, of that nature. This will be a site, it'll be a new building constructed where the solid waste is dropped in a new building with a roof, 4 walls, everything's contained. It will then be picked up on trucks and then taken to the landfill. So it promotes efficiency for ECUA. And I think it's worth noting that these trucks will only be using Pine Forest. They will not be accessing through Godwin Lane, which there is a traffic finding in our application from staff that supports that as well. And I have Mr. Bruce Woody, Executive Director of ECUA, if further questions are needed.
Very good. We'll go ahead with staff's presentation, and then afterwards we may be asking you some questions. Thank you, sir.
Allison Lindsay, Urban Planner, Development Services. So this is the request for 6722 Pine Forest Road to go from commercial to public. So in criteria 1, consistency with the comprehensive plan, the proposed amendment, I said it was not consistent with the intent and purpose of the future land use, which was mixed use urban, although they just got an approval for public. So then it would be consistent with the public future land use. The location of the existing facilities and services are consistent with the comp plan future land use 2.21 and 2.24, which states that the county coordination with the ECUA to consider upgrading existing facilities while minimizing cost and negative impacts. For criteria 2, is it consistent with the zoning, with the land development code? I did show a list of the commercial, the purpose of the commercial and also the purpose of the public zoning as well as the permitted uses. So the site is already developed and it operates by the Emerald Coast Utilities Authority who want to add a solid waste transfer station. The proposed request to the public is consistent with the current use as well as the permitted uses in the land development code for the public zoning category. The site has access on Godwin and also on Pine Forest Road. However, the transfer station will access the site via Pine Forest Road using the existing driveway. And the project will go through a development review for the new buildings, and it must meet all requirements of the LDC and be evaluated for consistency for the site plan review process. And also in the public zoning, there is no, most of our zoning categories have where you can do conditional uses. Well, public has no available conditional uses allowed. Compatibility with surrounding uses. So within the area of the property, the zoning districts were commercial, heavy commercial light industrial, medium density residential, and high density mixed use, with a more intense zoning along the arterial roadway of Pine Forest Road. Rezoning to public would be less intense and have less allowable density than the commercial or the HCLI zoning. spot zoning. The request would be considered spot zoning as there are no public zonings within the surrounding areas. However, public zoning by its own nature is an isolated zoning district, and it does not allow for residential development, retail sales, or services. The parcel is currently and will remain a public utility facility, and by doing so, it will correct any deficiencies in the land use existing today. Along Pine Forest Road, most uses are commercial or HCLI. Therefore, the request appears to be consistent with the existing development pattern along the Pine Forest Road. Appropriate with change or change conditions. The land uses or development conditions within the area surrounding and on the site have not changed. The surrounding area provides a mix of zoning categories from low residential to high residential and commercial uses. Thus, it would be in the public interest to allow the expansion which would support the area. That ends staff's findings.
Very good. So we come to the point of public comment, and we want to thank the public for being patient. And with this, we know it's also intimidating sometimes to get up in front of people we're used to because we do it every month, and these folks it's their job. We get that. We understand that. I want you to pay real attention to this portion of the script that I'm going to read. For the members of the public who wish to speak on this matter, please note that the Planning Board bases its decisions on the approval conditions and exceptions described in Section 2-7.2. If you'll pull that up for them so that they can see this and maybe it makes sense, resonates, of the Escambia County Land Development Code. During its deliberations, the Planning Board will not consider general statements of support or opposition. Accordingly, please limit your testimony to the approval conditions and exceptions described in Section 2-7.2. Please also note that only those individuals who are present and give testimony on the record at this hearing before the Planning Board will be allowed to speak at the subsequent hearing before the Board of County Commissioners. So we have a list of few folks here. So again, I would say, looking up at the overhead projector, looking at A through E, if you would formulate your discussion in that regard, because this board's job is only to recommend to the Board of County Commissioners that it should or should not go through. And we value your input greatly. We just, again, can't consider, I don't like it, property value, those types of issues are not what we're allowed to really take into consideration. So, the first speaker I have on the list is Tony Cole. And if you'll please come up and be sworn in and give us your name and your address, please. No Tony Cole? I understand that. So put that over there. Next would be Jack Smith. Thank you, Mr. Smith. And like I said, as you make your way up, if you would get sworn in and please provide your name and address. And you might want to pull that microphone down a little bit.
Jack Smith, 3041 Godwin Lane, Pensacola, Florida, 32526.
Yes, sir. And if you'll just note, we have a timer. We give everyone 3 minutes.
Okay.
And just go right ahead, sir.
Just a minute. Raise your right answer.
Yeah.
Solemnly swear in testimony about to give in this case with the truth, the whole truth, and nothing but the truth. So.
Yes, sir. Yes, I live parallel to the driveway of ECUA, and honestly, I have a couple concerns. I mean, naturally, we see rats all the time coming back and forth across the street, but within the last year, they had one truck that exploded, and it was sitting freestanding. If that truck had been in a building with 30 other trucks, it shook my house. It really did. And if that truck had been in a building with 30 other trucks, the whole neighborhood would have been like an atomic bomb. But it's, I don't know. I don't see them using Pine Forest as their, the trucks come in Godwin Lane all the time. And I know because they won't just use Pine Forest, they'll be using Godwin Lane. And it's just very frustrating. And another thing is, when the trucks are over there and they're washing the trucks down, what happens to all that drainage? That's gonna drain into, you know, my neighbors have cattle, they have sheep, they have goats, they have animals, you know. I have dogs. That sludge, it's gotta go somewhere. And I know they're not gonna wash it down a drain. So that's my major concern. All right, thank you.
Thank you very much. Next, we have Ms. Barbara Godwin. Come up, be sworn in, and state your name and address, please.
Raise your right hand. You solemnly swear affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth.
Yes. Yes.
And your name and address, please. You're good.
I'm a little hard of hearing.
We are too up here, so we're fine. That's why we use these, hopefully, to our advantage. And you can pull that towards you if that helps, and just state your name and your address,
I
ma'am.
do have a pretty big mouth, though. I'm Barbara Godwin at 3022 Godwin Lane, Pensacola, 32526. And of course, this ECUA is just within a few hundred feet from my home. And naturally, I'm concerned as to what goes on up there. I apologize for my voice. But after reading or looking at the A through E, I don't know if my speech is going to be in order or not. But our family owns about 50 or 60 or so acres that is on the east boundary of ECUA. And of course, we would be very much affected in a lot of different ways, which we're not supposed to discuss at this point. But we are concerned that there's still a lot of traffic on Godwin Lane and Community Drive going in and out of there, which Mrs. Campbell said they were entering from Pine Forest Road, but we still have a lot of truck traffic on there, a lot of noise from those trucks, and we're very concerned about the noise and the rats and explosions and you name it, you know. I have heard what their reasoning is for wanting to select that area, but this is a populated residential area, and it just seems like it would be to the county's benefit to locate a station like that in the outskirts of the county so that it wouldn't be a problem as much to anybody. I mean, nobody wants garbage under their nose, you know, but and I realize it's got to be put somewhere, but we certainly would like that to be considered if at all possible. Thank you.
Yes, ma'am. And I'll just clarify, when I state those criteria, that's all we can consider. Your testimony, regardless, goes into the record and will be, you know, as a public record. And you also get your day, if and when it gets to the Board of County Commissioners, then you can share your feelings with them as well. I just want to make sure everyone's clear. It's kind of a challenge. People don't, you know, a lot of people don't love to come up here and speak in front of, on a microphone, so I just want to try to put you at ease and try to explain the rules of the field here a little bit better. Next, we have a Daryl McClung. No Daryl McClung? Here, okay. Brooke Forrester.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
And if you'll just state your name and address, please.
Right, I'm Brooke Forrester, 6037 Dahoon Drive, Pensacola, 325.
37 what?
Dahoon Drive, Dahoon. Yep. Good. So Pensacola, 32526. I am her great niece, and my grandparents are in the back. And hopefully, many years down the road, I'll eventually get like inheritance. So I'm way down the road, I'll be living there. And our main concern, obviously, without mentioning all the things we're not supposed to mention, I understand they're going to build a building and they're going to put trash in there, and I'm sure they're going to say it's going to be contained. and it'll be just wonderful, but I don't see how it's humanly possible that we can put the county's trash in one spot and to say it's going to be contained and we're never going to smell it. I mean, that's not realistic. So number one, smell. Number two, the noise, and then obviously with the critters coming and going. But it's just moving forward. This is we've had the land since the 1940s, and for them now to start dumping trash there, even if it's temporary, that's not going to be a good thing for anything. So, we're going to smell it. So at the end of the day, that's a big deal. Big no. That's all we're going.
Thank you, ma'am. And I don't think I have any others. If there's anybody else who wishes to speak? All right. Not seeing any, I'll close the public comment portion of the hearing. Board members, do you have any questions for the applicant, staff members, or the public?
I have a couple questions for the applicant.
Please go right ahead.
My understanding is the ECUA is a governmental agency or quasi-governmental. Is that correct?
Yes, sir. And I think to answer some of these questions, if the board is okay with it, I'd like to call Mr. Woody as a witness to answer some of these general questions, if that's okay. I think that would help us.
That's really the only question I have for the applicant. Okay. I have a question for the staff. If this weren't...
And I'm sorry, the answer to your question was yes. Yes, sir.
Okay, thank you. If this were a non-governmental agency, what zoning would be appropriate for this type of operation?
Well, this zoning is appropriate for it. This zoning category that is does allow for this type of use. There are other zoning categories that does allow for heavy commercial, light industrial, but I believe this zoning category does allow for it. We would have to look at to make sure what is being proposed. I don't have my book in front of me for a solid waste transfer station, but I know that this zoning category would allow for it.
I understand. So if I was a private enterprise and I was going to do this type of operation, I could request public?
You can make a request for anything that you choose to do so. I mean, and I'm not being facetious. It's just they can make those requests, but of course we know what public is. There are certain for public uses. So staff will have to look at it, review, get with our legal department to address that specific question for you, because I've been there for 20 years, Mr. J. I never had that question before. But
yeah, just to clarify, my question is, what other zoning categories would allow this use?
Allison, look for solid waste transfer stations per se. I just don't have my book.
Sorry. Hey, sorry. It's conditional use in industrial.
Thank you.
I'm checking HCLI right now.
So that would be the only other option.
Solid waste processing in HCLI. Also.
With conditional use approval through the Board of County Commissioners instead of Board of Adjustment.
Right.
So to clarify, be conditional use under industrial
And HCLI.
and HCLI.
Mm-hmm.
And HCLI is across the street.
Yes.
So and remember now that would take another step up. It would take a two-step process.
And that's subject to approval by the Board of County Commissioners, not just the Board of Adjustment. So I guess part of your question, Mr. Stringwell, if I'm not mistaken, regardless of the applicant, be a public entity or a private business, they would, most likely staff would kind of herd them down the same path for the usage that's being described.
We would definitely take that into consideration, and we would definitely confer wholeheartedly with our legal department on that particular question. I never had that question. I don't want to say yes without me really looking at it complete and investigating, but that would be a consideration.
And also with the, with the public zoning, there's no retail sales, no retail service, and no residential. Whereas you have commercial or HCLI, you can do heavy commercial, light industrial, and a lot more intensive than the public.
And just looking at the map, if the 500-foot radius zoning map, the current, Yeah, it's up there. Would, if it was, if heavy commercial light industrial were proposed, would it be considered spot zoning
So.
in this case?
Sure. I mean, the adjacency is severed by the right-of-way, and you are adjacent to medium-density residential. Public zoning is more of a needs-based kind of category. We're looking for fire station property right now. We don't base that on location criteria. It's the traditional, we base it on response times and numbers of units. So public location criteria doesn't necessarily go with public zoning, just strictly because of those uses. They're very specific.
And that's what I'm getting at. The public is extended additional rights over a private enterprise if they were considering the same operation in this area.
Yeah, because so many of your government, your public uses have extremely specific criteria that are vastly different than a commercial enterprise would. Like a school. Or jail.
Yeah, I guess that's what I'm getting at, because they're a public enterprise, we're willing to extend additional rights for an operation that could be considered very intrusive in a MDR type setting, which we have here. So that's kind of where I'm going with this.
Board members, sir?
Yes, Mr. Chair. I was interested in the safety factor one gentleman mentioned. Y'all not going to be parking many trucks inside this building, right? It's going to drop off, and then you'll have somebody designated to transport to landfill?
Yes, sir, that's correct. Now, I was going to have Mr. Woody speak to that. The trucks will not be stored inside the new building.
Okay.
So I have a question for the executive director. So we could assume that trash will be on site basically 24/7.
He needs to be sworn in, probably.
Okay, I'm sorry.
Raise your right hand, you solemnly swear or affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
If you could state your name and
Yes, sir, I
address,
do.
please.
My name is
And your
Bruce Woody.
position.
I'm the executive director with the Escambia, Emerald Coast Utilities Authority.
And your address, please, sir?
9255 Sturdivant Street.
Thank you. Go ahead, Mr. Ingram.
Sir, my question is, so is it safe to assume that trash will be on site 24/7 at this transfer station?
No, that's not the purpose of a transfer station. Purpose of a transfer station, we're a public entity, so we're looking for opportunities for gain efficiencies and reduce costs. And right now, the operations are that all the route trucks individually have to take their own trips all the way to the landfill. By having a transfer station, those that are east and south of this location will be able to transfer their loads to larger tractor trailers and then more quickly get back to their own routes and do their work, and then we'll have less frequent trips to the landfill. So we do transfer from one container to the other, but the same day, those loads are taken to the landfill.
So you can guarantee that trash will not remain on this property overnight?
Absent an equipment failure or breakdown or something like that, yes, we'll be transferring.
And there's definitely a definition, and the Board of County Commissioners, basically, they're gonna be looking at all, there are other things that he got to work with the board on, and so if that's the board, so make a recommendation. This is definitely not the final outcome, even with him and other steps that he got to go through.
I would ask the director, sir, what's the current operation? What does it do now versus what the future? And I'm asking this question. Obviously, there's I don't know if it's a big PR problem or not. I mean, I know nobody wants trash close to them, but I just think the explanation for what has gone on and what will go on and what the differences are, if you think it's better, worse, or.
Sure. The ECUA operates and collects trash all over Escambia County, and over 30 routes located all over the county. Each of those individual route trucks currently takes an individual trip to the landfill. By having a transfer station, those locations that are largely east and south this transfer facility, instead of having to make an individual trip all the way to the landfill, which up in the northwest quadrant of the community, can transfer their loads at this transfer station. They eject a load, it gets transferred into a large walking floor semi-tractor trailer, depending on the densities of what's being collected at that particular route, getting anywhere from 3 to 5 loads into a single trailer. Then that single trailer makes the trip to the landfill. That's more efficient in terms of fuel savings, less labor intensive in terms of lost time waiting at the landfill. We get quite a bit of damage to equipment at the landfill, going through the active fill face, cut tires, cut hydraulic hoses, things like that going through the active fill face. We've even had equipment turn over at the fill face at times. So there's safety issues as well as efficiency issues. All that activity at the transfer station happens within an enclosed structure, not outside, absolutely not outside. And then at the end of the day, just as it is now, our collection route trucks are parked outside of structures for the evening.
Mr. Engwell?
Does the ECUA contract trash removal with surrounding counties?
We did have contracts with the north half of Santa Rosa County that expired last December.
So currently the answer is no?
For conventional trash. We do receive recycling goods from some outside communities, but that is done directly to our materials recycling facility, or MRF, over at the landfill. That's a separate operation.
So will any of those materials be run through this site?
No, recycling will not go through this facility.
Thank you.
I got a question for Horace.
Go ahead.
Horace, since ECUA is a public utility, should this have always been public instead of commercial?
To answer your question, I would say yes, but all of that predated me.
We're not blaming you.
Yeah.
Yeah.
all of that, it predated us. There were, so that was a decision that was made prior to Drew and I coming on board. So I had to throw Drew in here as well. So
Yeah.
If it was today, though, it would have gone to public, because it is a public utility.
it is definitely a public utility.
Okay, thank you.
Definitely.
I would ask just to try to address some of the public concern. One thing, either Horace or the director, when and if this does go through, let's say it goes past the Board of County Commissioners, and prior to their building this building, typically as a building or entity, we would submit to ECUA our plans for the filtration, the erosion, those type issues. How, and it was mentioned, we have agriculture to some degree in the direct vicinity. How are those for this building, who do they submit to for their plans in the development order stage?
Oh,
Again,
yes, yes.
not dealing with us, but when they go through this, number one, how is that affected? And B, I also wanted the director or you to also, I understand that most likely the truck explosion was something nobody wanted. It is an accident, it happens, but how and why would that, how is that going to be addressed, or would it be different in this operation because there aren't any trucks there? I'd just like to address those two items. Go ahead, Horace.
This would go through the same rigor through the site plan review process, meeting the same development standards, got to go through the same development code, and we will hope that because they want to be a good neighbor, because it's a public entity, that they will go above, because they want to be a good public neighbor, a good entity with the neighbors, that they will go above than just the minimum requirements for stormwater. But it definitely will go through the same review, site plan review process, just like any other commercial activity that meet the threshold, and it will. This definitely does. So a site plan review process, engineering, design, site plan review, all of those things. Even with the area came up about, and I know the director, I know he took note of that, about the truck traffic off of Pine Forest. We will, if that's the case where concerns, that will be addressed by the site plan review process. But Godwin Lane is I think it's a local street per se, and I believe that they're willing to, they already stated that everything will be coming through Pine Forest. And we'll be talking to the director with the board. We'll put a special project conditions if it goes to the next level of review on that. because I know they want to be a good neighbor with them. And there are other agreements, other regulations that he has to deal with the Board of County Commissioners on as a director. So making sure that they are good neighbors with the citizens of the Escambia County, as well as a good partner with the Escambia County.
Just to clarify, the garage facility and everything is still there, isn't it?
Yeah.
So the garage is
The
there.
maintenance
and
facility?
The
Yes,
garage
sir.
is there, and the trucks are parked there. They're cleaned on, they're worked on there, and employees report to work and leave their trucks and go home from that site. Is that all of the trucks, or is that just a certain group?
When you say all of the trucks, do you mean
All
the garbage trucks?
ECUA garbage trucks, are they all parked at that garage facility?
Yes, since we concluded our contract obligations over in Santa Rosa County, now this location is our sole location for
Okay.
collection
and
vehicles.
The second part of that question is, do they all enter and exit now? Maybe not all, but 99% of them, or whatever it is. Are they supposed to use an exit and entrance off of Pine Forest?
The refuse collection
So
vehicles,
so
yes.
y'all have switched from using the Godwin Lane entrance in
We
the
have,
past?
we have employees that use Godwood Lane, but the collection vehicles go in and out of Pine Forest.
Okay, all right. So I got you. Unfortunately, I didn't know where this was going, and I have a little history in the area. And, but Godwin Lane used to be the sole entry and exit for the garbage trucks. And I don't know when they changed that, but it could have been when they put the natural gas station there, I don't know. But the facility and the trucks have been there for eons, for 30 years probably.
Yes, sir, and as I was posting the sign and doing the site visit, several trucks were coming back to the ECUA facility off of Pine Forest Road, and I did see some of the employees that were actually leaving and waiting for being picked up off of Godwin. So yes, the majority that I did see were coming off of Pine Forest instead of the local road, which is what we desire anyway.
Board members, any other questions?
I have another question for
Go
the
ahead.
executive director. Is it your policy to only to empty the trucks prior to parking them for the night at the facility? Is that the policy?
Yes, it is.
So there's no, again, I'd like you to reiterate, there is no garbage that remains on site overnight.
Again, I'll have to give a qualified answer. As a routine order of business, yes, that is the policy. If we have a breakdown after hours, have a problem and the landfill closes before we get a load, then there may be occasions, but those are infrequent. And our supervisory staff are coached and encouraged to avoid that type of incident.
And if I may, Planning Board, also too, there were some questions about, you may want to, just trying to get these things on the table, just in case they come at the Board of County Commissioners meeting, because this quasi-judicial, about the odor control. I believe that they're going to try to meet all of the FDEP standards and the regulations concerning if there is any odor. They got to control that with all of the state environmental laws.
Board members, any other questions? For staff or the applicant? Hearing none, the chair will entertain a motion.
I'd like to approve Z 2021-14 as presented.
We have a motion. We have a second.
Second.
We have a motion and we have a second. All those in favor signify by saying aye.
Aye.
Any opposed?
Nay.
Who said that, please?
James, say you want.
Oh, wait, no, I'm a yay.
We know you.
I thought we were re-voting. I thought you asked for a show of hands.
All in favor. Mr. Ingwill's nay.
Mr. Ingwell's the only one?
Yes, sir.
Thank you.
All right, the motion does pass, and again, public, you get the opportunity That will be most likely heard at is that the January Board of County Commissioner meeting?
January 6th.
Okay. And all those that spoke here, you will also be able to speak there and share your concerns so that they go in the record. And obviously, we would encourage the ECUA to reach out and try to work with the neighbors to hopefully take some of that off. I know nobody wants trash in their backyard. It's something that has to happen. All right. I think we're done here. We have managed to wade through the agenda for the planning and zoning cases, so we will now adjourn. And if I recall, we do have our regular planning board that was in recession. I'd like to call that back to order. And I believe we are at the point where we are at action, discussion, info items. We have already gone through both small scale, or the small scale and the review of the development order. We're at the action items. Horace, staff, do you have anything?
No, sir, we do not.
We have, we're at the public forum. If the public has anything they'd like to share, now would be the time. Mr. Jones, it's a director's review.
I want to say, board, we know that we've had a long year with many cases, many challenges, and I think we accomplished. You all have accomplished many things. Some of the highlights, we were able to basically get OLFA, and whether people like it or not, but this board with again Terry Berry and John Fisher, and especially with the help of the commissioners, got that across. That was a long time coming. So board wants to say thank you for your service on this year. Looking forward to your continued service. Mr. Sammons, you got it for a couple of years.
I would, go ahead, I'm
Thank
sorry.
you, and want to say happy holidays to each of you. Again, thank you, planning board.
With inflation, we're getting a raise, right?
I will ask, since it's time for the county attorney's report number 1, thank you. You stepped in very well. We need you desperately, and we rely on our attorney, obviously. I would ask you this, briefly, to your knowledge, based upon the redistricting, am I out of a job? Or do we, subject to, Mr. Salmon is going to represent all of Perdido now and everybody else, or whomever else, but how does that affect the position here?
In all candor, Mr. Pyle, I do not know that answer today.
Good answer. I don't
You do run concurrent with the commissioner that has appointed you, those of you that are commissioner appointees. I would imagine that continues. And then,
What if you fall out of district, though?
well, you're an appointee by a commissioner. And I'm not speaking for Matt and for our legal department, I'm just saying, strict common sense, you don't have to be in a specific, I'm not aware of any requirement where you have to live in a specific location for a commissioner to appoint you.
And I will note, just for changing the topic a little bit, Ms. Johnson is recovering from a medical procedure from last week, so I'm covering for her today. I do hope she will be back at the next meeting next month, and then once she's gone, I intend to take over and sit with this board after that. But she didn't just leave you hanging. She will
Well,
likely be back.
our best well wishes, please convey those to Ms. Johnson. She's been a great advocate and help for all of us. If that is all, we stand in adjournment. Thank you. Hey, I'm going to leave this stuff here for Wayne. If I have it, it'll be gone.